This meeting of the Anderson Township Board of Zoning Appeals is hereby called to order. The board was established pursuant to Section 519.13 of the Ohio Revised Code by the Anderson Township trustees to provide administrative relief to any person or entity adversely affected by the Anderson Township zoning resolution. Will the secretary please call the roll?
Mr. Nye?
Here.
Mr. Syan?
Here.
Mr. Haber?
Here.
Mr. Halpin?
Present.
Mr. Shekels?
Here. Thank you for coming to this meeting of the Anderson Township Board of Zoning Appeals. Please be aware that this meeting is audio and video taped and may be carried live on television. First, I'll outline our procedures. A summary of the appeal is presented by the staff. Then the appellant will present its case. The board members may then ask questions of the appellant. And after that, all persons supporting the appeal will be permitted to testify, one at a time, after being recognized by the chairman. When these persons supporting the appeal are finished, those opposed to the appeal will then be permitted to testify and/or ask questions of the board after being recognized by the chairman. All persons wishing to testify, whether for or against an appeal, may only do so after being sworn in. When testifying, each person must come forward to the podium after being recognized, speak into the microphone, and state their name, address, and any affiliation to the case. All persons testifying will be limited to 4 minutes unless a board member requests additional time. All testimony is given to the board only. No comments or questions are to be directed to the appellant or anyone else in the audience. The board will only hear new, non-repetitive evidence or questions. Should someone wish to show support of previous testimony, they may do so by following the testimony procedures and stating their support of previous testimony. Now, will all persons who may give testimony this evening, please stand, raise your right hand, and swear or affirm. Let's see who's standing. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Are there any changes to tonight's agenda?
We don't have any changes to the agenda, but there was a revision to the staff report for Case 7. That was done on 4/4. That was also posted to our website, and I believe the board received a copy.
Right. Everybody here got one? Okay. Hearing none, the agenda is approved by unanimous consent. Are there any changes to minutes from the previous meeting?
I made some revisions to it, which were included in the packet.
They're in the packet?
Yes.
Okay. Hearing none, the minutes are approved by unanimous consent. Okay, will the staff read the summary for case 3-2022? And I'd like the board's feedback on whether we can carry 3 and 4 together since they're in the same subdivision, involve the same size. Are we good with that?
Yes.
Okay,
Yeah.
we'll carry both those cases together. And then case 4-2022.
Great. So thank you, Mr. Chair, and appreciate everybody's patience this evening. We have several cases, so we'll get started here with cases 3 and 4. Case 3, the applicant is Lisa Wharton on behalf of Wharton Law LLC. On behalf of Coldstream Estates Development LLC. The property is Ayers Road, Book 500, page 183, parcel 14. Property is AA Residence, and the applicant is requesting a variance to allow an existing 4-by-5-foot temporary sign to be located on the property for 3 years when the maximum permitted time is 48 days. The proposed development again is the 4.
Hey, Brad, can I interrupt you for a second? Last time the applicant wasn't here. Are you here for the applicant this time? Okay, sorry. Go ahead.
Yeah.
Didn't want to go through it if they weren't here.
Yes, thank you, Mr.
I
Chair.
apologize. Sorry, that's fine.
A little bit of
For
history.
Lisa Wharton, I'm sorry.
A little bit of history, and again, this will be for both case 3 and 4. In March 2021, staff received complaints about 3 temporary signs on Asbury and Ayers Road that were related to the Riverview Estates at Coldstream subdivision. After inspecting the signs, staff found them to be in violation of Article 5.5E of the zoning resolution. And staff believes, based on the staff report, or based on the applicant's submittal, that the signs were installed in around 2007. In July 2021, the applicant submitted plans for a 26-lot subdivision known as Carriages at Coldstream on the portion of the lot in question, and that was approved by the Anderson Township Zoning Commission with Case 3, 2021 PUD. In October, the applicant applied for variances for the 3 signs to remain. Staff determined one of those signs were actually in Hamilton County's right-of-way on Asbury Road, and I believe the applicant has applied for a permit through Hamilton County Engineers Office for that sign. And then in January 2021, the applicant submitted plans for the PUD that was previously approved. That's a 7-lot subdivision known as the Views at Coldstream, and that case was approved by the Anderson Township Zoning Commission on February 28th. So again, case 4, this is the same applicant on behalf of Mark and Gretchen Tahar, who are the property owners of 202 Coldstream Club Drive. The request is to allow an existing 8-foot by 4-foot sign to remain for 3 years, while the maximum time is 48 days. So all the previous history that I mentioned is the same for case 4. The only thing in addition to this one is in August 2017, we issued a zoning certificate for the 20-foot by 5-foot subdivision entry wall. And then in August 2001, a zoning certificate was issued for the house that's currently construction on the property. The sign in question is in the public right-of-way on Ayers Road, so if approved, the sign would need to be relocated outside the right-of-way. So this is the 2 sites for both cases 3 and 4. This is one of the existing signs. I believe this one's 5-foot by 4-foot, and then this is the additional sign. That 3rd sign that we mentioned that's in Hamilton County's right-of-way is this sign up here, and that is not being considered tonight. This is an aerial view of the property. As I mentioned, a few subdivisions were approved on this portion, kind of the eastern half of that lot. And this is the topography map. So this is the site plan for case 3. Again, this sign is near the corner of Ayers and Asbury Road. This is the 4-foot by 5-foot sign that's existing. And again, staff believes that it was installed around 2007. The applicant may have more information about that. And then there's another view of that sign. Here's a couple of pictures that staff took while we were on site. Uh-oh. One second. That's not good. All right. It's not going to let me connect because I'm not on that drive anymore. It's going to take me off, kick me off the do what? I think I need to download. I'll be right back. Sorry for the technical difficulties. The PowerPoint is acting up. I'll be right back. PowerPoint. All right, sorry about that. Again, this is the existing sign at the corner of Asbury and Ayers. And then this is the property map for case 4. Again, there's a house that's currently under construction on this property, and the existing subdivision entry sign for that subdivision is located there as well. And there's a topography map. You can see there is a small lake on the southern portion of the lot. And then this is the site plan for that sign. And a few renderings. I believe this one is 8 foot by 4 foot. And this is the sign that is currently located in the public right-of-way. If approved, it would just need to be moved back to be 10 feet from the edge of the road. And here you can see the house that's currently under construction. So here, staff findings, and again, this is for case 3 and 4. Staff's of the opinion the variance could be substantial. The 2 signs in question, including the sign proposed in case 4, have been in violation of the zoning resolution since 2007, as stated in the applicant's submittal. Further, the Riverview Estates at Coldstream subdivision was approved in 2006, and according to our records, staff has issued zoning certificates for single-family homes on all but one of the 20 lots for that subdivision. The essential character of the neighborhood could be altered. Temporary signs in residential districts, which are greater than 8 square feet, have size and time restrictions in order to be aesthetically harmonious with the surrounding community. As stated in the application, the 2 signs in question are of high-quality construction, are well-maintained. However, the size and number of signs being proposed could impact the residential character of the neighborhood. Variance would not adversely affect the delivery of governmental services. The property owner's predicament can be feasibly obviated through some method other than a variance. The property owner could install smaller temporary signs up to 8 square feet, which are permitted in residential districts without a time limit. And staff is of the opinion that the spirit and intent behind the zoning requirement may not be observed, and substantial justice may not be done by granting the variance based on the length of time that the signs have been in violation, the number of developable lots in that subdivision, and the impacts the signs could have on the residential character of the neighborhood. We do have a few recommended conditions for case 4. If approved, the applicant shall submit a revised site plan showing the sign being located outside the right-of-way, and that sign needs to be relocated within 30 days. So here are standards to be considered. As Mr. Nye mentioned, we did have public testimony that was heard last month for this, but like I said, be happy to answer any questions.
No. The testimony was against the
I
signing,
believe,
correct?
yes.
If I was here for that.
Yes, and
Yes,
those are
okay.
noted in the minutes from last
Okay.
month.
Are there any questions from the board?
Nope.
I'd like to commend you guys, as always, both of you who do an outstanding job of preparation for these meetings, okay? Will the appellant or the appellant's representative please come to the podium, speak into the microphone, state your name, address, and any affiliation, and present your appeal.
Hi, my name is Edwin Ferrugia. I'm with Coldstream Estates Development, LLC. Our address is 7861 East Kemper Road, Cincinnati, Ohio, 45249. So yeah, the 2 signs, the one at the corner of Asbury and Ayers and the corner of Coldstream Club and Ayers Road. Those signs, I know in the staff report it mentioned that they've been there since 2007. That may have been a typo in our application. They've actually only been there since late 2017, possibly 2018. I know that's still quite a bit of time, but it hasn't been since 2007. Those signs are in place to advertise the site that is Riverview Estates at Coldstream Country Club, where there was a 32-lot platted subdivision, 1-acre lots that you can see the Coldstream Club Drive, and then the private drive as well. So we do still have about 12 lots for sale back there. We'd like to keep the signs there, obviously, because it brings traffic back there. And As it was also mentioned in the staff report, we've got a site of 26 homes going on the opposite side of Ayers Road, and another 7 lots that have been approved as well. So in an ideal world, the sign at the corner of Ayers and Asbury would probably get new language on it, so we would kind of keep that sign there. And then I can tell you that at the sign that's on lot 27 at Coldstream Club Drive and Ayers Road, the one that's in the right of way, we agreed if you guys do approve, we'd move that out of the right of way. And secondly, that sign would probably be coming down around the end of the year or early 2023 when the residents occupy their home on that lot. As I stated, yeah, it's an active.
That's the case 4? I'm sorry.
Yeah, the case 4 sign, yes, sorry. So yeah, I mean, we would obviously want to keep the signs there currently, because we do have a lot of activity back that way in regards to development, and we'd like to get people back there to see where we're building.
Any questions to the board?
So, sir, you said in case 4,
Yes.
when that house gets occupied, which you stated towards the end of the year, is that sign will come down?
Yes.
What about the other sign? When will it be coming down?
Well, if we're approved, 3 years from now, because of the location, that location where the case 3 sign is, that gets people back in the Coldstream area. And we would like to, and we'll be developing and probably building back there for the next 2 to 3 years. So we'd like to, that would be that would be there for, I would say, 3 years. The one at the other one would not. Case 4 would not.
Thank you.
Any more questions from the board? Is there anyone else present who'd like to speak in favor of the appeal? Is there anyone here who would like to speak in opposition to this case, to both cases? None appearing? Okay. Hearing no further comments, and if there's no objection from the board, we need a motion to close the public hearing on cases 3 and 4.
So moved.
Second.
Will you call the
Mr.
roll?
Nye,
Aye.
Mr. Sion,
Aye.
Mr. Haber,
Aye.
Mr. Halpin,
Aye.
Mr. Shekels.
Aye. Jeff, would you like to start out the conversation?
Well, they've been up for 4 years already, and 3 more years is a long time. I appreciate the need to attract people back to the site. I can't ever remember us approving something remotely this long. I think there was the one on Clough Pike a couple of months ago that we approved for about a year, if I remember right. There's the one, I can't remember the name of the street, but it's down the right end of this map, right? If you go back down that private drive, you kind of go over the little hill, and there's one way back there where only really the one house sees it. I don't remember how long that was, but it wasn't 3 years.
That was earlier this year, and I think it was only a 1-year extension.
Okay.
Is that the Homoramo?
No, that was all single lot.
No, in the same area.
So it's a very long time. I think with respect to case 4, they're saying, we know we applied for 3 years, we really just want to do the end of the year. Maybe we give them the end of the year, but that's mostly built out anyway. I'm not really sure I need it. I don't know, it's a long time. I guess that's my thought. Maybe I could be convinced. If it's been up 5 years already and 3 more years is a heck of a long time.
Yeah. Paul, do you have any comments?
We did receive some testimony from staff as well too, that there's a size issue, that if they want to reduce the size, move it back, maybe the setback, then that might be acceptable. That's we did get testimony 2 months ago from somebody who did was opposed to having those signs up. So there's options there. I guess it just depends on where do we want to go with this?
Steve?
Question. Before we get off Mr. Science, options, have you any idea what options?
And we do have, kind of going back to the initial point, we do have the, you know, they can have the signs, it has to be within a certain size and with setback at a certain point, and there's no issue.
Right.
That kind of seems to me to be, you know, I guess there was no testimony presented why one sign is better than the other. Does it attract people versus the other sign?
Right.
I mean,
Right.
so everybody has that ability, and we're not necessarily denying that, but.
To make a conforming sign.
Correct.
Okay. Okay, thank you. Yeah, I'm in agreement with Mr. Nye. I think 3 years is a long time for it having been up 4 or 5 years already. And I was trying to follow Mr. Sion's notion about what kind of options we have. You know, that they could take down the sign and put up another sign, and if it was conforming, it works. And if it's not conforming, they can come, you know, and request, I guess, a variance for the size of the sign, but it can only be up for 48 days. And so to me, I'm just getting into a circular notion. So my thinking is, and I'll maybe take Mr. Nye's a little bit further. Case 4, it's going to come down maybe in 7 months. The other one up for another 3 years, to me, is a long time, in light of the testimony that we received at our meeting earlier, which was not in favor of granting the variance.
John?
Well, you got 12 lots on case 3. They're yet to be sold. And on case 4, I agree that it's only a short period of time, so that sign's not going to be there very long. I also agree that the time frame is a little long. I think that we should know at least once a year how many lots are sold and whether or not we want to extend the use of the sign for another year. So I'm thinking a 1-year term. That's my thought.
Quick aside to the general public, you may be thinking, why has this been going on to 17? We do not actively go out and look for zoning violations, okay? The violations have to be reported to us or come through the building permit process. That's the only way. We do not actively solicit. Okay? My thoughts are twofold. On 4, I'd be in favor of having that signed up through the end of the year. My concern is that property owner owns that property right now, and this goes to the property, not the property owner. And if we were to extend that for a couple of years, and he gets a building built and sells and decides to move somewhere else, then the new person that moved in there is stuck with that sign there for another X years, whatever we would agree to. And that's why on the case 4, I would give the extension to the end of the year. On case 3, I would definitely extend it for a year. I would agree to that. And I could go to 2, or we could adopt John's philosophy of 1 year, and it can come back in next year and ask for another and show cause as to why, you know, none of the lots sold, or we got this going on, and we'd like to extend for that reason. I like your idea, John.
Can we go, can I ask staff to go, the aerial view map, can we flip back to that? Yeah, I think this is the one. Maybe I misunderstood here. There's a planned development for, how many houses was it on the eastern part of that property?
So it's 2 separate subdivisions. One of them is 26 lots and one of them is 7 lots.
And they're both approved, PUD approved.
Correct.
And are they both on the eastern part, or does that take up the whole parcel?
I think they're both on the eastern part of the property.
So kind of nowhere near the sign.
I would,
I'm not so much asking you, I'm commenting to the board.
yeah.
You know.
I agree with you, but at the same time, if you're coming down that street,
Oh, here, yeah.
Yes,
okay.
this shows one of the subdivisions, and I believe the 7 lot one would be to the south. Yeah. And I also wanted to make a clarification. So the property owner for case 4, if we were to issue, if this were approved and we were to issue the zoning certificate, it would go in the property owner's name. And if they wanted it removed, then they would have the right to
He would have
remove the sign.
at sale, he would have the right to take that off?
I believe so, yeah.
Okay, that's what I was
You can always
concerned
take it
with.
down, You can't always put it up.
Okay, or if he didn't like this, he could leave it up.
Correct.
To further that discussion, Mr. Chair, I can extend case 3 for a certain amount of time, but I am not in favor of tying it to performance. That we're dealing with a zoning issue here and not a selling real estate issue. So I could be convinced to extend that one sign for a certain amount of time, but I'm not in favor of having the appellant come back and say, hey, I haven't sold any, I need to go for another year, and then come back again in another year and say, well, I sold 2.
We're
or
not
something.
telling
I
him he has to
don't-
do that.
I
yeah,
don't think
yeah.
we should tie it to performance of sales.
Well, no, but I'm saying at the end of the year, if it's up and he decides he wants to extend it, he's perfectly well entitled to come back to us and say, I would really like to extend this another time, correct? Yeah. So if, I'm not saying that has any part of the deal, but if we extend it for a year and a year they decide they want to try again, he'll come back through the appeals process.
I agree, I don't think it should be tied to the number of lots.
Yeah,
So
I'm not either. I'm not
I just
tying it to any
think that-
performance.
the sign's gonna stay up, or they're gonna want the sign up as long as they have lots to sell. So it's always nice to know if any have sold, to get an idea of how long the signage is gonna be needed, or get a sense of it.
Okay.
How many acres is the whole thing? Oh, I've got it here somewhere.
Pretty good size, I'd
It's
say.
big, but it is all one lot, is that right?
Currently it is. I don't believe the subdivisions have been subdivided or recorded yet.
Like, I'm trying to think of another situation, again, yeah, I know every case has to stand on its own, but I'm trying to think of another situation where the sign advertising the subdivision is so far from the subdivision. And it seems to me like if they were asking for a sign saying, this is the kind of house we're gonna build right here, I think I'd feel differently about it. But to put it at the corner of Ayers and, whatever the corner is, Asbury, yes, thank you. Like, how many cars are coming up Asbury Hill and saying, oh, maybe I should go look for a new house over here? I think, my guess is 0, you know?
If I could just have you guys speak into the microphones.
Sorry, I'm not speaking in the microphone. What was that, Paul?
And in the price range of those houses too.
Yeah, I feel like, I don't want them to not advertise their house, their development, but my guess is that sign isn't really doing a lot. And shouldn't that be something we should consider? You know, what is the point of this?
Well, I understand the point of it from a business situation, you know, and whether it actually gets the response or not is a separate question, you know.
Right, so, like, if we're gonna let them do something that might not be effective, shouldn't we at least make sure it's not an eyesore, as the neighbors apparently think it is? You know what I mean? So I think what I would say is, I'd be okay with a sign like this for a shorter period of time where the street is. But down there, over there, put a conforming sign up or don't put a sign up.
Are you talking about
That's what I would
4?
think.
Are you talking about 4?
No, I'm talking about 3. Like
okay.
this yellow dot over there.
Okay.
You know, put that where the little street is over on the right. You know, I think that makes sense to me. But down there, it doesn't make a lot of sense to me. I don't want to tell them how to advertise their business, but it seems like, given the fact that neighbors have complained, I don't know.
I did have a comment, and I guess maybe a question for Mr. Powell. The applicant mentioned changing out some of the language on the signs. With that, generally, for a permanent freestanding sign, we would do a face change zoning certificate. If they were to do, change some of the language or a face change after these were approved, would that require zoning approval or to go back through the Board of Zoning Appeals as well?
I don't think so.
Okay.
I mean, I think if the variance is approved for, a temporary sign there for a particular period of time, I think, that would cover, the changing of the face of the sign. But I do want to remind the board that, when you're dealing with temporary signs, you're looking at content neutral regulations. So you can't get into the, what the sign says and what its purpose is, things like that. I mean, a temporary sign is a temporary sign. And, you also have to look at the standards for the variance in the, in the zoning resolution as well. So you have to make sure you tie that back to that. And, so I would, again, ask you to look at the sign itself and not the purpose of the sign, other than they want to put out a message to someone, but we can't regulate the content of that message.
I think the other comment that I have is, and Mr. Chair, you noted it earlier, in that we don't go around the township looking for violations. If we put a time stipulation that one goes to the end of the year and the other one goes towards a year, is staff going to be able to enforce that? Because obviously we've been here at 5 years, and I'm not looking for necessarily, and again, no judgment here, but self-regulation by the appellant. Is are we doing something that we typically don't do in saying we have to enforce these time provisions?
If it had a time frame tied to it, and if that were a condition of approval, once that time period's up, it would effectively be a zoning violation, and we would treat it like any other zoning violation, and they could either take it back to the Board of Zoning Appeals if they want to keep it up, or we would need to proceed with filing charges in Hamilton County Municipal Court.
And that's something that you would be willing and charged to do?
I think we've done it for other signs, and it's really up to the board.
Okay, so if we put a time stipulation, then we'll be looking upon you to review it and enforce what you just said.
Correct.
Okay, thank you.
Can you take it to the picture of the sign? There.
So this is the one at the corner of Asbury.
Yeah.
And then this is the one further into this subdivision.
Giving the testimony of staff right there, I'm probably willing to allow both of these signs to exist until the end of the year. Not 1 year here or 3 months for the other sign, is to include both signs through the end of the year. And this, that should give this, the majority of this year, the opportunity for the appellant to sell those additional lots.
So you're saying through December 1st, not 1 year from today?
Right.
Yeah.
Right.
Okay. Did you want to make a motion to that effect?
No, I wanted to hear other people's opinions. Other staff positions and responses.
I'm okay with it.
Concur as well.
Mr. Nye?
Yeah, sure, I guess. I'm looking at the standards and I'm thinking, will the property yield a reasonable return, or whether there can be any beneficial use of property without a variance? The answer to that is yes, that weighs against the applicant. The variance is substantial, maybe it is. The essential character would be altered, I think on 4 it wouldn't, and on 3, testimony from the neighbor last time suggests that it was. So on 4 it doesn't weigh against him, but on case 3 it does. Delivery of governmental services, that's no effect there. Property owner purchased the property with knowledge of the zoning restrictions, that weighs against them. The property owner's predicament can be feasibly obviated through some method other than a variance. I don't know what the predicament is, so that weighs against them. Spirit and intent behind the zoning requirement would be observed. We're talking about having a sign that's ultimately up for 6 years. That does not feel like it is within the spirit and intent of the zoning requirement. So I feel like, I know we don't necessarily just count these up and, majority wins, but it feels like most of those factors weigh against the appellant here. So, but the big thing is, what's the neighborhood like? Is it substantial? I think it's kind of a close call. It is kind of out in the middle of nowhere. So that makes it seem less substantial. But it seems like a conforming sign would get them what they need, point people in the right direction, and, respect the neighbors. So I guess my inclination would be to say, on 4, sure, leave it up to the end of the year, but on 3, take it down. And put up a conforming sign and, put your advertisements out there.
And a conforming sign would be,
I forget the details, but it can be a certain size for a certain period of time,
Up
and
to,
as long as it's so far from the roadway, right? I mean, it's,
up to 8 square feet can be installed without a zoning certificate
For how long?
with no time limit.
No time limit. Okay.
yeah,
so that'd be like a 2x4.
exactly. I mean, just like this, is that notice of zoning hearing a 2x4 sign? It's a little smaller than that, probably. That's probably like 6 square feet or something.
I'm not sure.
So roughly the size of that, a little bit bigger. All you're trying to do is get someone that's coming down, I forget which street is which.
Asbury.
Asbury, say turn left, not right. That's what you're trying to accomplish, I think. I think you could do that with a conforming sign, and I think then the neighbors who don't like the sign,
Now, is this sign case 3 or is that case 4, that sign?
That's-
that's 3.
I know it says 3,
But that's case 3.
That's
Yes.
sweet.
4 is the one near the pond.
so this one is the one that's gonna come away, or go away.
No.
No, the other one.
No, this is the one they want 3 more years. The other one they said, probably come down at the end of the calendar year.
Because that house will be constructed afterwards.
Okay, yeah, got it.
Again, it's like standing alone, I might not have objected to that sign, but the only neighbor we've heard from says, yeah, the sign's an eyesore. Or I don't remember exactly what they said, but there have been complaints. There's testimony to that effect in the record.
I would support to the end of the year on both sides. Would anyone like to make a motion to that effect?
I really appreciate your going through our standards and making those, really understanding those. And that's why I made sure that you had comment here. No, because we're trying to work out zoning here. And if it doesn't comply, and I appreciate the comments, is if it doesn't comply to our standards, then we should not grant the variance and let the appellant then create another sign there that would conform. And so I'm going to make a motion here. And how do you want these? Individually or together?
Whichever you prefer.
Whichever I prefer. Well, I get pretty wordy, so. Okay, so, Mr. Chair, regarding case 3-2022 BZA, I move that we decline granting the variance. I don't think there's anything more that needs to be said
Second.
other than that.
And I would second that motion.
Mr. Nye,
Aye.
Mr. Cyan,
Aye.
Mr. Haber,
Aye.
Mr. Halpin,
Aye.
Mr. Shekels.
Nay.
Okay, so then for case 4-2022 BZA, I move that we grant the variance for a time extension of the existing sign until December 31st, 2022. hold on, let me. That the applicant shall submit a revised site plan showing the sign being located outside the right-of-way. That the sign shall be located outside of the right-of-way within 30 days of this date, and that the sign be kept in good condition.
Second.
Mr. Nye,
Aye.
Mr. Sion,
Aye.
Mr. Haber,
Aye.
Mr. Halpin,
Aye.
Mr. Shekels.
Aye. All right.
Do we have to have a motion to come out of session?
No,
Thank
I think
you.
we can just move on.
We just move on to the next case? Okay, all right.
If I could just make sure everybody's speaking into their microphones, and then,
Sure. Okay. Would you present case 5, 2022?
yes, this case will be presented by Riley, our Township Co-op.
All right, I will be presenting case 5, 2022 BZA. The applicant is Kyle and Nicole Simonillo. They are the property owners. This is located at 2691 Little Dry Run Road, Book 500, page 220, parcel 422. The zoning is A residence. The applicant is requesting a variance to allow an 8-foot privacy fence in the front, rear, and side yard, where only a 6-foot tall privacy fence is permitted in the rear yard, and a 4-foot high fence that is 75% open is permitted in the side and front yard, per Article 5.2A 9 of the Anderson Township zoning resolution. The applicant has proposed to construct an 8-foot tall privacy fence in their front, rear, and side yard. The applicant has already installed a 6-foot high wooden privacy fence with 8-foot tall posts along the southern property line. The additional 2 feet in height would consist of a lattice top on top of the existing 6-foot tall privacy fence. The fence is 128 feet in length and is located in the front, rear, and side yard areas of their property. Article 5.2A 9 of the Anderson Township zoning resolution states that 6-foot tall privacy fences are only permitted in the rear yard, while fences in the side and front yard shall not exceed 4 feet in height and must be at least 75% open. Here's the property map. History. The house was bought by the current owner in August of 2016. Between 2017 and 2019, vegetation on the southern edge of the property and the neighboring property was cleared by Duke Energy. In November of 2021, planning and zoning staff sent a letter to the property owner in regard to the 6-foot tall privacy fence that was in violation of Article 5.2A 9 of the zoning resolution. Here's the property map. The fence is located along that southern border of their property. An aerial. And then at the top, the topography map, there is a slight decrease in grade from north to south. Here's the site plan. So the fence is located on that southern property line. It's 128 feet in length. They also proposed a 1 to 2 foot tall stone wall with high grass and flowers that's about 20 feet long. Here's photos submitted by the applicant looking from the fence north, then looking west down the fence, south at the neighboring property, and then another photo from behind the fence looking at the neighboring property. Here's a photo looking north back at the house, looking south at the neighboring property, looking west down across the property. Just another photo looking across the property. Staff is of the opinion that the variance would be substantial. The proposed fence is 8 feet tall and solid, which is 4 feet taller than the permitted in the front and side yard area. and it's 2 feet higher than the permitted height in the rear yard per Article 5.2A of the zoning resolution. The essential character of the neighborhood would be altered, and adjoining properties would suffer a substantial detriment as a result of the variance. The 6-foot-high existing fence is highly visible from Little Dry Run Road. Furthermore, there are no 8-feet-tall privacy fences in the surrounding neighborhood, and no 6-foot-tall privacy fences in the front or side yards of any houses in the neighborhood. The variance would not adversely affect the delivery of governmental services. The owner's predicament could be feasibly obviated through some method other than a variance. They could build a 4-foot-tall, 75% open fence in the front and side yard area, and a 6-foot privacy fence in the rear yard, and those would both be in compliance with the zoning resolution. The property owner could also install vegetation outside of Duke Energy's easement to create a privacy screen. Staff is of the opinion that the spirit and intent of behind the zoning requirement would not be observed by granting the variance based on the high visibility from Little Dry Run Road, the absence of other 8-foot-high privacy fences in the area, or 6-foot privacy fences in the front or side yards of other properties in the area, and the fact that the predicament can be feasibly obviated through some other method other than a variance.
Are there any questions from the board? None? Okay. Will the appellant or the appellate's representative please come to the podium, speak into the microphone, state your name, address, any affiliation, and present your appeal.
My name is Kyle Simonello, 2691 Little Dry Run. I'm here to talk about the variance for the fence. It all came about, we bought the property. There was trees next to my house. The Duke Energy increased their variance by 25 feet on both sides of what the property line was prior to me buying the house. So we had 2 large trees that were on the south side of my house that were cut down along with many other trees. And the same thing, vice versa, to the property to the southern side of my house also. So basically the variance comes up to my house. So there's no opportunity to plant trees there. And then that's another 50 feet to the other guy's house also, south. The fence is, there's a lot of information. The first is that it wasn't November of 19, it was last year. So I can't plant any vegetation. So every 5 years, Duke Energy would come and clear that land. So before I did anything to that property, there was a wire fence, 4 foot tall, and trees that would grow up, X amount of feet, 10, 15 feet. So when I bought the property, the vegetation was 10 feet high. I couldn't see my neighbor's house. I was there for 2 years. They come by, clear it, and they just cut it down and leave it a mess. So then I cleared all the property, my neighbor's property included. And then I established the fence. It is 60 feet past my backyard to the front of the 6 foot at the moment. I knew I was stretching it with the 2 foot lattice fence, but as one of the pictures clearly shows, there's about a 2,000 square foot deck on the south entrance, on this S1 picture there, on the back of their property, which looks right into my yard. So you can see, like where those posts are, that's their deck when they stand there, and which is a very nice asset to their property, but then they spend a lot of time out there. So they're just overlooking my property. So there's my want to put the 2 fence lattice there, 2 foot lattice. I mean, the 60 feet that's in question, I asked all my neighbors. Nobody complained. And the guy that's selling the house is the reason I'm here. Obviously, I'm very well aware that I did not look in. As I put in with my paperwork, the Duke Energy guidelines for what could be established there is what I followed. So I took in consideration that since they own the property, that's why I overstepped my bounds, and that's why I'm sitting in front of you guys now. I see my mistake, and not here to argue or but I do not feel that it's detrimental. As you can see, the road curves back and kicks back where the property is, so there's a good 70 feet from the street. My house is tilted a little bit, so the back of my house even kicks back, considering if it was just level. The property behind me on the other side, their backyard's facing my backyard, and it's not past their backyard. These are all just ideas I'm throwing out there to try to get the idea across that just trying to make it look better, and just have some sort of privacy for us, because there's nothing outside of the tall grasses that I've already put there. But then what do? Put some kind of scenario, or just, I mean, kind of wish I'd just let it grow up every 5 years, and then I'd have privacy for 2 years and 3 years. With all that being said, I mean, everything else is pretty straightforward. The lines are dictated. I'm just asking for the variance. And as my neighbors and myself felt before I did this, and they all have commented that it does not deteriorate from the neighborhood. And I'm hoping that that can get across here to the council. I do believe that is everything. Thank you.
Any questions from the board?
Yeah, the picture at the bottom right, where was that taken from?
That's in my backyard. So that's like legit okay, except for the 2 foot that's okay there. So that's the 6 foot fence is okay right there to that point, to that last pole.
Mm-hmm.
So then I would lose the last 6, 1, 2, 3, 4, 5. I'd usually lose the last 5. So it's like 48 feet over, because each one's 8 foot.
Here's one of the reasons I'm asking. If the goal is to shield your house from the neighboring deck, I'm trying to like draw a line from the deck through the fence and see where it ends up on your property. Because like the front of the fence isn't shielding your house; it's shielding like the middle of the street or across the street. Can you take it down closer to the street so you don't need a variance? If it's 4 foot for the first 3 sections,
But wouldn't
whatever,
it have to be 75% open though at the same time?
It would be, but a 4 foot solid fence and a 6 foot solid fence or an 8 foot fence, whatever, is a very different variance request. Than, do you see what I'm saying?
Yeah, absolutely. I mean, this whole thing with all the ideas and me pushing the 8 foot, there's a lot of subject matter in here that's crossing the line on a couple things, and I get that. But as you can see on this picture, for example, the road is coming at me this way. So as it bends to the bottom there on the south side, as you're coming around that turn, you can see straight into my backyard immediately. So like even like a quarter mile back. So as soon as you're coming around that turn, you're over here, and then the road kicks back here. So you're looking into my backyard. That's why I chose to go to that distance, to try to like block the view from like when you're coming around the corner like that. So yeah.
This view.
Exactly. So like you cannot see, you can still see into my backyard right there from my neighbor's driveway, for example. And I didn't want to take it any farther because then I thought that would be obtuse. I needed my, because it's barely in front of my house. And so that's what I'm trying to stop, right? So that's my neighbor's house, and you can still see in my backyard. So it's not blocking my backyard per se. And then so I was going to do the high grasses, put my little flower bed up front to add the decor, tie it all together, because again, it is under power lines. There's not many options.
Okay.
And I went with the
appreciate
cedar
that
fence. I don't know. I went with the more expensive and longer lasting of the two.
Well, is that out in the easement area where Duke is?
That whole fence is dead center under the easement area.
So are you going to have trouble with Duke?
No, I've followed every guy. So when they did this, they put a piece of paper in front of me. They said, "This is what we're doing. This is why we ripped all your stuff down. This is why we cut your trees down." And so I followed every variance in Duke's guideline. That was in my proposal. I put their guidelines in there.
Okay.
Go ahead.
Can I ask you a question about those guidelines? You got them here. I don't know if you guys looked at them. Number 2 says, fences shall not parallel the center line within the rights of way.
The rights of way is so that when they come like this, so
Fences shall not parallel the center line. Which your fence does. So, like, whatever we say, is Duke going to come in and say, hey, you can't parallel the center line?
And again, before I did this, I called and told him what I was doing. And I don't know if that's even the correct wording. It's supposed to be, it shouldn't go perpendicular, because when they bring the machines down.
That's what I thought. But then
I
look
think
at what this says.
Because after I talked to the guy, I didn't even, as I looked at it, now that you said it to me, it doesn't make sense. But as I talked to the guy, we were never in question on whether it was, they just don't want it to be perpendicular. So when they bring the machines, they can take the machine from XYZ and run it down the
Straight
line.
down the line.
and
That's
run it
exactly
down.
what I thought.
That's why I didn't put anything on the backside. So as I went over this and made the call to them, I think that's, I'm not 100%, but the guy I talked to seemed like I was doing the right thing. I wouldn't have moved forward without at least doing that. And I was just unaware that there was even this kind of scenario where I was, I Googled, if you Google, is there a fence permit? In Ohio, it says no. And I just didn't take the right due diligence to make sure I wasn't making a mistake.
Mr. Chairman, may I ask a question?
Yeah.
Duke came in and expanded their easement by 50 feet. I assume you were compensated for that?
No. Absolutely not.
How did you own the property? I mean, do you own the property between your house and the fence?
Yes. And as that, go back one picture. One more. See, you can see that straight sign on the west view.
Mm-hmm.
All that property, all the way back, all the way to Wilson, is unoccupied by the property owners because of Duke's easement. So, like, 4 houses back is the Wilson Elementary School, and all that the whole thing was just covered in thorns. And so, like, all the people that own that property that meets up there, they just don't do anything with it. I was the only one. The house across the street fought Duke because they tore down all their trees, whether they got any money or not. I didn't feel like it was my right to argue. They said they lose $1 billion a year in trees, so they increased it 25 feet on each side. But no, I was not compensated, to answer the question. But it did open my house up for everybody into my windows. My neighbors can see in my windows. Even that's another reason why it's so far forward. Our kitchen's on the one side. You drive by, you can see right in our kitchen.
I just don't understand how they could acquire easement from a private property owner without paying for it.
Well, I don't understand half of this, so I don't have the answer. I apologize.
Okay.
But I did not get compensated. Maybe I should go back on that and see if I can get some money from tearing down my
I
nice...
can't give you legal advice, but it might be a little bit late now if they already have the easement.
Well, the people across the street, they lost their battle and they tore down their trees, and none of them were going to be remotely close to the power lines.
The answer is probably the Duke always had the right to go as far as they did, and they just hadn't yet.
Well, they increased it by 25. It was...
They increased what they cut down, but they probably always had the right to go to where
Yeah,
they went to.
they
Is
wouldn't
my
have to.
guess. It doesn't probably.
Maybe
matter,
that one,
but-
yes.
To
But-
go, Jeff, you read the sentence that contradicts each other. Tree species are, it says are not underlined allowed within the wire zone, period, with no exception. And then the next sentence, they take an exception to that.
I mean,
Trees are approved in the border zone.
Well, that's
may
the
not
border
exceed-
zone,
yeah,
not the wire
53.
zone.
Well, I don't know what they mean by the
Oh, the
border
next
zone.
page. Next page has a little diagram.
Yeah, I know.
The
but
wire
I'm-
zone's in the middle, the border zone's
They
on the
either have
side.
an easement or they don't. They don't get to carry over their easement for another 50 feet just because they want to.
Well, I mean,
Yeah.
again, I don't think it matters. My guess is that they have an easement, or if not an easement, some kind of right of way from the edge of one border zone to the other. And if they didn't trim edge to edge before, well, now they are. You know, they always could have. They just hadn't.
But
you know.
this was an updated, that version. The version prior, they told us that they had changed their guidelines when they came out the last time. Those trees that they cut down were there for a good 15 years. And they were not near the power lines. I mean, I would only hope that this is just a unique situation that I can
Yeah.
get some kind of... In the 4 foot, I love any suggestions other than just be cut and dry. I mean, I'm not here to argue, but to better the area, to improve the property, to give some kind of privacy is the goal here, and to make it look better. It is under a huge power line. I mean, I'm losing on that already.
Yeah.
You got any more to present?
Oh, no, sir.
Is there anyone else here to speak in favor of the appellate? Anyone? Is there anyone here to speak in opposition to the appellant? Okay. All right, neither one. Hearing no further comments, and if there's no objection, go ahead and entertain a motion to close the public hearing on this case 5.
So moved.
Second.
Mr. Nye,
Aye.
Mr. Sion,
Aye.
Mr. Haber,
Aye.
Mr. Halpin,
Aye.
Mr. Shekels.
Aye. Anyone like to lead the discussion?
I'm okay with it.
I'm not in favor of the 8-foot, because I don't want to go down that road, and I think that that's a significant step.
I agree with it and understand it, but I'm thinking this is a unique situation, and it allows for the exception as opposed to recognizing that if somebody else comes along down the line and wants an 8-foot fence, they don't get the exception necessarily. That's my thought. I understand the logic behind what's happening here.
Jeff, you look like you're about ready to say something, but can't figure it out.
This is an unusual one. We have to take each property on its own. Every parcel is unique. There's no such thing as being really unique. But this is really unique, right? The power lines make this unlike almost every other parcel. And so often our answer in these cases is vegetative screen. Well, they can't have a vegetative screen. How many parcels in Anderson Township can't have a vegetative screen? Not many. This is one of them. So I'm inclined to be lenient in that respect. There is no other way he can feasibly obviate his predicament. As to how substantial the variance is, you come around that corner, whether you're coming north or south, and you definitely see the fence. But, because of the way the power lines cut through there, I kind of thought it was going to look worse. I had this image in my mind of what it might look like. I kind of thought it was going to look worse. I haven't heard any testimony from the neighborhood that it's affecting their property or anything like that. That's something that we tend to give a lot of weight to. So I don't think the essential character is really altered. I agree, from looking around there, being familiar with the area, that where staff says there aren't any other ones like this. Of course there's not. But nobody's here saying, hey, get rid of that dumb thing. I do think, maybe knocking it down to 4 feet for a portion of it might address some of the concerns to the extent the board has them, up till at least in the front yard maybe. And I'm looking at this picture here. If you cut that by a third, you're still just under that top board. That seems like that would be high enough, 4 feet tall, 100% solid, to shield most of the backyard, I think is my instinct. Now, whether...
So are you just saying that in the fence that's in the front of the house, or are you saying on the side of the house, cut it down to the
Well,
length
I
of
was
the side?
gonna talk about the side next, but I think the front yard, like up until you're even with the corner of the house, you could cut 2 feet off that fence, probably still achieve the same purpose, and it's less of a variance. It's easier to justify. In the side yard, whether you keep it at 4 or whether you go to 6, I don't know. It's kind of a closer call. It's not really clear to me where front stops and side begins on here, how many sections you have to go back to the front yard. But I guess I'd like to hear what other people think about that. With respect to, can we go to the photos again, looking at the neighbor's house? Like the photo, yeah. So looking at the one on the bottom right, put a 2-foot lattice on there. That makes sense to me. You don't, the idea is to screen the porch. If you stop it at 6 feet, you don't screen the porch. And you're already allowed to have 6 feet in the backyard. He doesn't need a variance for that.
Right.
So then you're only getting a 2-foot variance. And that doesn't seem unreasonable to me, given how far it is from the road. It's 100 feet or whatever from the road. It's pretty dang far from any other house. it seems reasonable to me, all things considered. We can go through the factors, we sort of have, but I think if you cut it down to 4 feet for some portion of the front, then it's probably fine. And even if you don't, maybe it's fine. I don't think I'd bring an 8-foot lattice all the way to the front. That might be a little much to me. 6 feet plus 2 feet. No, that's okay, sure.
There's just one section that's passing on front.
Just one.
And again, the 8-foot lattice is only, I just didn't know how that would look if it was this. Does that make it look better, or does that make it look worse? There's why I wasn't.
Yeah. I mean, I'm thinking of that place over on Immaculate Lane, or I think it was.
Yeah.
And they had all those fences, and we made them take down that lattice at the top of their fence, but it was also like 6 feet from their neighbor's house. It was like leaning over their back patio. This isn't that. I mean, so I'm inclined to grant it as modified, is what I would say.
And you would modify it as?
I think I would take it down from 6 feet to 4 feet for the front section, and then
Anything past the front corner of the house towards the street?
towards the street, I'd say keep that down to 4. Whether you go right up to 8 there, or whether you want to angle it up, or maybe even you say 4 feet at the front, but then slope it up to 8 feet by the time you get to the front of the house, maybe even would be okay.
And I wouldn't, if that's the case and what we agree on, I wouldn't want him to go, that front of that house in that 8-foot section is not going to hit at the same spot.
Yeah.
So I wouldn't want him to go halfway through his fence and try to cut it up and put bracing in and all that. I'd just take it to the next
Go to the post.
behind the front of the house.
That's
If
the way
that's what-
I'm leaning on all. Yeah, something like that. I don't know what everyone else is thinking.
I would take the section down, one section, literally, and if it is, it's a foot or two. I didn't measure the line. The house is slanted like this, so one side of the house is past that, and the other side of the house.
Mm-hmm.
So which side is this?
That's a question for staff. Well, before we go to there, though, I mean, I may be the only one who thinks this.
No, I like your
Paul
idea.
maybe does, but
Yeah.
I'd like to hear what everyone else says. I've talked a lot today.
Okay with it.
Yeah, okay.
What'd you say? Okay with it? Well,
It sounds like the owner is too.
it's interesting that it's called a fence because it's made of fence materials, but it isn't a fence in the normal idea that
Oh.
it contains
Right.
something. So I call it a shield, more than anything. And I think because of the unusual circumstances, Mr. Knight noted it being a Duke easement and all of the vegetation having been eradicated from it leaves, I think, the owner in some kind of a predicament. I don't have a problem with the 8-foot high tall fence. If the appellant is willing to take out that first section, as he's just mentioned, so that we're not encroaching into the front yard, that's a help. But I wouldn't cut anything down and angle it up. I just think it needs to be a rectangular shield or something that is holistic and is similar from end to end.
Paul?
Yeah, as Mr. Nye said, it's a unique case. You deal with the power lines. I drive that particular route pretty frequently. And, if you told me driving, I would have never noticed it was an 8-foot fence.
Yeah.
From,
And I would tell you the same way. I drive that all the time, and until the case comes up, I never noticed the fence.
Yeah.
Okay. Well, Jeff, would you like to put together a motion?
No. Some of the other folks are so good at that.
What, our
Steve?
designated motion man?
Man.
No, I'll do it. I got it. Okay.
You
so,
sure? You sure?
Well, Are you proposing to take down that front 8-foot section, or?
That's what we have to do. I'm obviously I'm interested. But yes, I will. I am proposing that. Let's just make.
Okay, then I move that we grant the variance as modified by the applicant.
With me taking that fence down.
I'll second that motion.
You're looking at me like you wanted to add something.
Would you call the roll?
Hold on. Did you want to add something?
You want-
You didn't want to modify it. You'd leave the whole thing up?
No.
Oh.
No. Is we just to make sure, is we're granting an 8-foot high eight-foot high fence, the installation of lattice work to get up to 8 feet, and then removal of the first bay of fencing.
This is why you should have made the motion. I think the proposal is the applicant is modifying the application or the appeal to remove the section of the fence or shield closest to the road.
Yep.
Okay, otherwise, we're granting. And that's 6 feet plus 2 feet, total of 8 feet.
2 feet of lattice.
And so now it's, instead of 128 feet long, it's gonna be 120 feet long, I presume. 8-foot sections?
Yep.
You got that, PJ?
So moved? And we got a
So
second?
moved.
I second it.
Second.
Second by Paul. Fine.
Thank you. Mr. Nye,
Aye.
Mr. Sion,
Aye.
Mr. Haber,
Aye.
Mr. Halpin,
Aye.
Mr. Shekels.
Aye. Shuffle my cards here. Okay. All right. Would the staff read the report for case 6-2022?
All right, so case 7 tonight is going to be at 1311 Wolfangle Road.
Case 6.
I'm sorry, case 6. The applicant is Edward Schmidt, who is the property owner. The property is zone C residence, and the variance request is for a 24-foot by 26-foot private garage addition with a rear yard setback of 11 feet where 30 feet is required. All right. The applicant's proposing to construct a 24-foot by 26-foot private garage, and again, the rear yard setback would be 11 feet where 30 feet is required. A little bit of history. The house was constructed in 1959 and purchased by the current owner in September of 2021. In November of 2021, a zoning certificate was issued for a deck in the front yard along Wolfangle. And then in March of 2022, an 8-foot by 7-foot open porch addition was approved. So this is a map of the property. Again, so this is a corner lot on Wolfangle, and this is Town Center Way here. This is Bowen in this direction. Here is an aerial map of the property. I believe a portion of this wall has been removed, and there's currently gravel on this portion of the lot. This is the area where that addition would be. This is a topography map. And then here's the site plan that was submitted. So the highlighted area on here is the garage addition. The other zoning certificates that I mentioned, one was for a deck in this portion of the yard, and then an unenclosed front porch right here. And again, the setback would be 11 feet from the property line. Here is a front elevation of that garage addition. As you can see, it'd be right here. Here's another elevation of the property, of what the garage would look like, and then this is an elevation from the side. So this is what I guess the condos would be looking at. And then this is a picture that staff took on site. This right here would be the area that the porch would be going. Like I mentioned, this is the gravel that's on a portion of the lots. There's another view of the front of the house. As you can see, the front porch, and I don't think the deck have been installed yet, but they have been approved. There's another view, kind of looking from the corner of Wolf Angle and Town Center Way. As you can see next door, there are a couple garages for the condominiums. And then another view where that garage area would be, and again, there's a dumpster next door as well. There's another view of the existing garage, and then right across the street we have the Kroger parking lot, and I believe this is kind of the click list area. And then this is what's right next door on the adjacent property. So staff findings, staff's of the opinion that the variance would not be substantial as the property is a corner lot with a limited rear yard. The essential character of the neighborhood would not be altered, and adjoining properties would not suffer a substantial detriment as a result of the variance. Proposed addition is planned to match the existing residence and the building style. Further, the proposed addition would be adjacent to the garage and dumpster structures for the condominiums to the west. The variance would not be affect the delivery of governmental services. Property owner's predicament could be feasibly obviated through some method other than a variance. A detached structure up to 585 square feet would be permitted to be constructed in the rear yard with only a 3-foot setback. However, the applicant prefers an attached garage to be consistent with the existing house and more aesthetically pleasing. Staff is of the opinion that the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting a variance based on the fact that the property is a corner lot with a limited rear yard. Further, the garage addition would match the existing residence and would be adjacent to the existing garage and dumpster structures for the property to the west.
Any questions from the board?
Oh, we do have one, staff recommended condition. If approved, we just would want to get a revised site plan showing that the driveway will be paved after completed.
Any questions?
Yeah, would you go back to the photographs? Yeah, keep going on looking at the front of the house. A little more. That one right there. You said there was a deck that was approved
Yes,
in 2021,
correct.
and looks like it's been enclosed, or is the deck,
I don't believe the deck has been constructed yet.
thank you, it is not.
Is the date on your camera a year off?
Yes, it is. Sorry about that. Sorry about that.
Okay. Thank you.
Is the appellant or the appellant's representative present? Would you please come to the podium, speak your name, address, and any affiliation, and present your appeal?
Ed Schmidt. I live at 1294 Wolf Angle, catty corner to the address I'm working on. And what else?
What?
I'm the owner.
Yeah, will you present your appeal?
Tell us anything you want to tell us.
Tell us anything you want to tell us about why we should grant this.
Well, I guess the first thing I'd like to start off with, if you have any questions for me before I go ahead and do all this, and then we can nip it in the
We
bud.
prefer to go the other way. You tell us why you want it, and then we'll ask you.
Okay, I have a habit of buying property on corner lots, which kind of rise the problems all the time. So, like I said, I live on the other side of the street. I saw this house. I found out from Crocus it was for sale, so I bought it because it's the house that I like. I'm a carpenter by trade. I like brick, so I don't have to do anything to it, except a garage and a deck, and I put a front porch roof over the front porch. I think by doing that, I'll be able to get my vehicles in a garage instead of parked outside in the elements. Since the house was built in 1959, the vehicles don't fit in the garage. I have a pickup truck. It won't come close, so. The other car I have will, but I was going to buy something bigger, but I'm not buying that now, so. It would, so it would be more, I think it would be more appealing if I would have a house, a garage attached to the house, because I can keep the same lines, and it wouldn't look out of place. If I detach a garage and put back there, like I could do without a variance, I think it looked more cut up. And I like the way it looks being attached, and it's also nice having an attached garage, so you don't have to go out in the elements to your garage. With that being said, there was a wall there. It's gone, where the gravel is, that's all gone. So I'd be able to pull straight in, yep, right there. It was a wall, partially fallen down. So I either had to build another wall or take it down. So I don't like walls, so I took it down. And then at that view there, it's going to be flush with the front of the house. And it's all going to be the same siding. And that's about it.
Okay, thank you. Any questions from the board?
You gonna make it out of brick?
No,
Okay.
I can't lay brick. My grandfather could, I can't.
Other question is what?
It's going to be vinyl siding, just like what's on the end of the eave of the house.
Right. What are you gonna do with the wall, the concrete wall right there?
What I want to do, I want to get some, they call it slap and stick. You ever hear of slap and stick stone?
Uh-huh,
That's what I want to put on the front of that.
okay.
And I want to bring that, I didn't show it on my other picture because I just came up with this since I was at the tile store yesterday. I want to put that across the front of that, and then when it comes down, like where between the garage doors, I want to kind of wrap that around with about 2 foot, maybe 3 foot high, with that same type of stone, and on the end, and probably bring it around the edge of the garage a little bit, and then on going to the other end, on that far porch, I was thinking about doing it on the front and side of that porch, to kind of all bring it around. And then the two posts.
Put stone on it around the bottom of that porch?
Mhm. And then the 2 posts that will be holding the front porch roof up, I want to bring it up 2 or 3 foot so it all ties together.
Do you have a picture of the front? Or maybe the drawing of the front? Yeah. So over on the right-hand side where you've got that enclosed porch, that bottom brick there
Yep.
is going to make stone?
I was thinking about it. I was going to see how it all goes.
And then you're going to take stone where the grade was up to the wall on the front of the house?
And
And then at some point, how high above the grade in the garage are you going to then take stone?
I was thinking about maybe 3 foot, 32 inches, something like
Take it all
that.
the way around, or the front and the side?
Not the side, just go around the corner.
Just
and
go
then-
around the corner?
And then break it
And then
down
do it vinyl down?
in vinyl.
You know what I'm trying to get at here? Is, to me, you've got a really nice composition where you've got a house in the middle and then 2 similar elements, one on each side.
It balances out, yeah.
And it balances out. And
I
that's
know,
why I'm
yeah.
talking about materials with it. You're gonna build it yourself?
Yes.
Okay. And this gets you access then into, from the garage into your other garage. Okay.
Any other questions?
No.
Is there anyone else who would like to speak in favor of the appellant? Is there anyone who would like to speak against the appeal? Anyone who would like to speak against the appeal? Hearing none, if there's no objection for the board, we will close this meeting and the public part of this meeting.
Move to close. Sorry, yeah, I need a motion.
Second.
Mr. Nye?
Aye.
Mr. Sion?
Aye.
Mr. Haber?
Aye.
Mr. Halpin?
Aye.
Mr. Shekels?
Aye. I'll start one for a change. I never do that.
Oh, shucks.
To me, I'm in favor of this 100%. The owner has invested in the property, and we really need to, we appreciate that as a township, okay, that you're investing in your residents. And I think you have a really nice plan here. Would not suffer, the neighborhood would not suffer a detriment. You would actually be improving the neighborhood from what I've seen. And that's all I have to say.
To continue what I was questioning the appellant with before, architecturally, as simple as it is, it's a really nice solution to it, and that's why I wanted to talk about some of the materials regarding this. We've got, it's almost within a commercial location. You've got the garbage and dumpsters and the other garages right to the left of this. This is a really nice solution in my viewpoint. And there's no objection to the adjacency to the property line to the, I guess that's to the north, so I'm in favor of it.
Any other comments?
Concur, I'm in favor. I think it's going to improve the neighborhood, improve the value of surrounding properties. I would add that I would agree with staff's recommendation to pave the gravel portion of the driveway.
Okay.
Other than that, I'm in favor.
Do we have anybody here who'd like to make a motion?
Mr. Chair, regarding case 6-2022 BZA, I'll get closer to the microphone, that we grant a variance to allow a 24 by 26 private garage addition with a rear yard setback of 11 feet setback of 11 feet period. I'm going to include staff's report. A couple conditions: that the applicant shall submit a revised site plan noting that the gravel portion of the driveway shall be paved with a hard, dust-free surface to be approved by staff. Substantial conformance with the drawings dated March 14th, included in our packets. Construction to be commenced within 1 year and completed within 2 years.
A second.
Mr. Nye?
Aye.
Mr. Sion?
Aye.
Mr. Haber?
Aye.
Mr. Halpin?
Aye.
Mr. Shekels?
Aye. We've been at this for 2 hours. Does anyone need a 10-minute break, or should we continue?
Keep on going.
Keep going. That's okay.
An hour and a half.
Oh, an hour? Well, if I could tell time, this job would be easier.
As I recall, you missed a meeting not that long ago because you could
Would the staff read the summary for case number 7-2022?
All right, so for case 7-2022, the applicant is Michael Murray on behalf of Sherry Murray, who's the property owner of 1259 Sutton Road. Property is Zone C residence, and the applicant is requesting a variance to allow a 103-foot tall and a 67-foot tall amateur ham radio antenna, where a maximum height of 35 feet is permitted per Article 5.2A3. Applicant is requesting a variance to allow for a 103-foot tall and a 67-foot tall ham radio antenna structure to be located in the rear and side yard of the property, where the maximum height is 35 feet. The applicant is a federal communications licensed amateur radio operator for both hobby and emergency/disaster communications. The applicant stated the proposed height of the antenna is needed for reliable radio reception. The house was built in 1940 and purchased by the current owner in 2011. In 2012, zoning certificate issued for a 4-foot high split rail fence. Upon inspection of the property, staff noticed that there were 2 existing antennas on the property. The applicant is proposing to relocate the existing antenna from the side yard area and co-locating it on the existing 67-foot tall antenna, which is in the side yard. In accordance with House Bill 158, the Board of Zoning Appeals shall not restrict the height or location of amateur radio antenna structures in such a way that prevents effective amateur radio service communications, and shall comply with Section 47 of the federal
Code of Federal Regulations.
Thank you. This is a property map on Sutton Road, and then this is an aerial map. So the 2 existing structures, as I mentioned, are, one of them is in the side yard area near where my pointer is, and then the other one is kind of in the front yard area. You'll see that in the site plan. This is a topography map. So, and again, this was revised on 4/1/2021. The radio or the tower that's on the front of the house is being relocated to be on this second tower, and then the number 1 here would be the new structure, which is 103 feet tall. Number 2 is 67 feet tall, and according to the applicant, it's a monopole structure. This is an elevation drawing that was submitted by the applicant. So here, this is the rear of the property, the rear of the house. A portion of this structure has been constructed, but this would be the total height of 103 feet. So here is a view of the front of that property. You can see both the existing antennas on the property now. This one on the front of the house is the one that would be relocated to that second location. So this is those same 2 structures. To get an idea of the height of what that structure would be, we went and took our township drone and flew it to approximately 103 feet, which is where this arrow is right here. As you can see, this is the existing structure that's being proposed to remain.
Wait, which one's remaining? Which?
I believe.
No, that one's going.
No, you're
The
right.
one on
This
the
is on
left.
the front of the house. This is the structure on the front of the house. The one that would remain.
Yeah.
It's tough to see. It's kind of hidden by the tree right here. Here is a portion or the base of that new structure, and then you can see the structure in the side yard here. I believe the pole in the side yard does have guy wires, and the new pole would have guy wires as well. I think the applicant can provide more information on that. Another view of the rear yard area. And then this is a photo that was taken with our township drone. So this is, again, the existing structure. And you can see the base of the new structure here. There is an existing commercial radio tower in the area as well, or cell tower, which you can see in this picture near the intersection of Salem and Sutton. And then this is another view kind of from the front of the property looking back towards the rear. You can see the existing structure here, and the new structure would be approximately in this location. So staff findings, staff is of the opinion that the variance could be substantial. The proposed amateur radio antennas will be 103 feet and 167 feet high, where maximum height is 35. In addition, Article 5.2A3 requires that antennas be set back at least 1 foot for every 2 feet in height, meaning the antennas would need to meet a 34-foot and 51.5-foot setback from the property line. I don't believe setbacks were provided on the site plan.
Okay. Is it 30 foot from the side and 51 from the rear?
No, it would be, so basically,
Two antennas.
the setback is half the height of each tower. So
Okay.
for the 103-foot one, it would be 51 feet from any property line, or maybe the rear property line, and then 34 feet for the 67-foot tower. The essential character of the neighborhood may not be altered, and adjoining properties may not suffer a substantial detriment as a result of the variance. The property in question is approximately 600 feet from a 160-foot high telecommunications tower on Sutton Road. In addition, there is a large mature tree located on the front yard of the property that would screen the proposed antenna from Sutton Road and neighboring residences to the southeast. The variance would not adversely affect the delivery of governmental service, but may aid in communicating during an emergency or disaster. The property owner's predicament can be feasibly obviated through some method other than a variance, as they would be permitted to install a 35-foot tall antenna. However, the applicant has stated that if the antennas were lowered, it would severely limit the ability to broadcast due to the existing mature tree and would create interference problems for surrounding properties if the antenna were 35 feet. Staff's of the opinion that the spirit and intent behind the zoning requirement may be observed and substantial justice may be done by granting the variance. The reason for the height of the antennas is to allow the applicant to broadcast for both hobby and emergency support. The mature tree surrounding the antennas, which the applicant indicated causes reception issues, also screens the proposed and existing antennas from the residences to the southeast. So this is our set of standards. I'd be happy to answer any questions.
Any questions from the board?
You said that we don't have property line setbacks on our plan, right?
I don't believe those were provided. This is the site plan that was received.
So the property width there is 75 feet, so I say it's roughly 35 feet from that property line to the south. Number one is, and number two is 10 or so feet, probably.
That sounds about right.
Any further questions? Is the appellant or the appellant's representative here? Please come to the podium, speak into the microphone, state your name, address, and any affiliation, and present your appeal.
Thank you very much, and good evening, and thank you for your time. My name is Michael J. Murray. I live at 1259 Sutton Road here in beautiful Anderson Township, Cincinnati 45230. And my affiliation is the Amateur Radio Service, and that is K8QBL is my granted call sign. Over the last year or so, I have been building a bit of a radio station up, and things are going quite well. Well, I've hit a snag, and that snag is broadcasting UHF, VHF into a tree. That's ultra high frequency and very high frequency. Now, if we go lower to avoid the tree, that goes into people's bedrooms, and that's not a good thing. We have power restraints. We have a site plan that we do put together to make sure that no one is in an RF danger zone. At 30 feet above, everybody is nice and safe, especially my neighbors, which are very important to me. And as a matter of fact, speaking of importance, so is this community. I have a lot of volunteer hours in. I continue to volunteer. I'm an active part of ARES. And not only is this antenna for the hobby, as was stated, it is also for emergency communications should the little devices we call cell phones just stop working one day or there is another emergency. That's one of the reasons we're here. The other one is it's just an absolutely tremendous hobby. It's as good as it gets. It's learning, and there are no finer people that you could ever meet than amateur radio operators.
Is that it?
That's it.
Okay, questions from the board?
Help me out just with the terminology to start. see the term tower and I see the term antenna. Help me understand the difference.
All right, sir, it's very simple. An antenna is a device that receives or radiates a signal. And if you take an insect's antenna, while they are very tiny, they do receive or transmit signals as necessary. Well, an antenna is something that transmits or receives a signal in my case. All three of these antennas provide different bandwidths. Some are very, very affected by direct things like vegetation and foliage. Others, because of their takeoff angle, go nowhere near it. Getting the upper two as far away from that big tree as possible opens up a great deal of territory for me and does expand my VHF. VHF is very high frequency. Think old TV stations. UHF, think channel 19. There are different frequencies in that sector, but of course these are in the ham bands. And then HF is literally global and national communications.
Okay, so you've got a number of different antennas, and the tower is just the physical support structure? It does nothing but hold up the antennas? Is that
That is the whole purpose of the tower or amateur radio support structure for an antenna. There is no antenna that actually violates the zoning laws as written, because I will have no antenna with a physical height of 35 feet or greater.
It's the tower that is...
Yes, that would seem to be the point of consternation here, sir.
I wouldn't say it's consternation. I'm just trying to make you understand what we're talking about. So you've got two right now. You're going to move the one onto the other one that's already there, and then you're putting up a new one. Is there some reason you can't put them all on one tower?
Yes, sir. Tower space.
Okay.
Very frankly. The 2-meter 440 antenna, which is going on top, which is currently on the side of the house, is a high gain antenna. The higher off the ground I get it, it's what they call line of sight communications. Plus, it gets me pretty much right at the top of the tree line, so I get a lot better broadcast pattern. The one right below it is a 16.5 degree beam antenna, which focuses energy and transmits longer, but you lose the omnidirectional hearing ability of a single vertical pole, if that makes any sense to you.
Kind of.
The one on the front of the house is a 24-foot 6-meter stick. That will be moving to the side yard. The one on top of the side yard pole will be moving to the top of the tower, sir.
Okay.
Will wires be needed to anchor that, or will that base that you have the tower in be substantial enough to hold the whole?
Sir, to properly construct this without any form of danger to my neighbors from both torque, wind speed, and, well, here in Ohio, the occasional earthquake, believe it or not, it will be a guide structure. The tower itself is not designed to be freestanding. It's designed to be guide, and that is what actually limits the rotation or the torque on the tower. The base you saw poured is 10 feet, rebar reinforced, with 3/4 inch stainless steel all thread going through there to mount the base on.
So wires will be attached?
Yes, sir.
And they'll extend out to your backyard,
Yes, sir, and one to the front yard over the house.
over the house?
It's attached at 20 feet at the house, it will be attached at 40 feet, and it will be attached at 60 feet.
So three anchors in total?
3 anchors, one is the house itself. The other pole on the side of the house, it is 43 foot tall. The last 20 feet is guide. One is guide to the roof of the house. The wind loading on that is very insignificant, and since there is no beam antenna or sideways antenna, as it were, on this one, the wind load is fine just by using a standard high-quality rope guying.
And I take it the tower is grounded as well?
Yes, sir. The tower will meet and hopefully exceed most of the grounding standards for amateur radio.
Thank you.
You're very welcome.
Any further questions? Hearing none? Okay. Anything else you'd like to present?
Thank you.
Okay.
We'll now take testimony from anyone who here to speak in support of the appeal. Is there anyone here? Please raise your hand if you are. One? Okay, come up. You were sworn in? Okay. Please come to the microphone. Speak your name, address, and any affiliation.
Okay, my name is Dan Woody, and I live at 6250 Birkinshaw Drive, Cincinnati, Ohio. And I'm also amateur radio, call sign KC8ZUM. So I know Mike through amateur radio, and I'm also a neighbor of his. So I've been to his house, I've seen all of this, and he's correct that not having the antenna higher will impede his communications, especially on VHF and UHF. A good example of that is, for example, for like the Forest Hills School District, for the buses. You guys have a tower behind Station 6. That's where the repeater is for that. In order to have coverage just of the township, you guys had to put that tower up and put the antennas up on top of that. That's over 200 feet, I believe. So 100 feet is half that. So if that gives you some idea of the reasons for this, that's one of the main reasons. It's to provide coverage. So.
Anything else to contribute?
I think that's about it, unless you guys have any questions.
Okay. Any questions from the board?
Do you have an antenna, a tower?
I don't yet. I haven't put anything up yet. I do plan to at some point.
We
I
may
do
see you
also,
back here, huh?
Yeah. Yeah, exactly. I should also mention I do work in federal government radio communications. That's what I do for a living. So I worked for Motorola for 7.5 years, and I currently work for a company called Comdex Consulting.
Okay.
So.
Thank you.
Okay, thanks.
Is there anyone else who would like to speak in support? Anyone in support? Is there anyone who would like to speak in opposition? Please come to the podium. Speak your name.
Hi,
Address.
my name is Jay Schiller. I live at 1250 Sutton. I'm directly across the street from Mr. Murray. And my concern is that the structure is 100 feet, 10 stories high. And when I stand at my kitchen window or I stand on my porch, I'm looking at a freaking pole. And that just kills everything. The tree is not blocking the pole from my house. And so that is a concern for me. I spoke to my realtor as we are thinking about putting our house up on the market, and she said this will do nothing for your property value. That this could be detrimental. And then my first concern is, does that pole need a beacon or anything like that on it? I'm concerned about cell phone communication, Bluetooth communication, LED. These are all things in your home that are low level, that could be affected by that tower. So I got.
Thank you. Any questions from the board?
You're directly across the street?
Directly across the street.
Are there any houses between you and the, I forget the name of the facility there?
Salem Gardens?
No,
The nursing home?
Are you right next to the nursing home there?
No, so there's 3 houses on that, more or less. So you have the nursing home.
Yeah.
Then you have a house, then my house.
You're the second one, okay.
I'm the second house, and then there's a third house.
Okay, I was just trying to picture it. Okay, got it.
Jeff, any more?
No.
Any other questions?
Okay.
Okay,
Mr.
thank
Chairman.
you. Is there
Mr. Chairman.
anyone else who would like?
The witness brought up some issues about radio interference with other things in the vicinity. That's not within the zoning board's power. That's up to the FCC to control. It's not part of our consideration here.
Correct. Okay, thank you. Anyone else who would like to speak in opposition, please come to the podium, give us your name, address, and state your relationship.
Thank you. My name's Jennifer Morehouse, and I own the home located next door to Mr. Murray at 1267 Sutton. We just recently purchased the house back at the end of October of last year. I think I'm all for hobbies. I think it's wonderful. I'm all for what you're trying to do. But what it boils down to is if you construct this tower in the back of your house, every window in the back of my house, I'm going to look out and see this tower. And then to come to understand now, there's going to be cables coming over the house. I mean, to me, it looks like a tower with a circus tent in the middle of a residential neighborhood. As my other neighbor stated, that's going to just drive our value of our homes down. And that's a huge concern for me, considering we just bought it at the height of the market, and we don't need anybody helping us drive that value down. The only other thing that I had to say is I did a little bit of research before we came today. I understand the safety part of it. I understand the emergency part of it. But just based on a Google search in the greater Cincinnati area, there's over 36 cell towers in the same fashion that he wants to construct. So if we did have that kind of catastrophe going on, we have enough towers around.
Anything else you'd like to present?
The only other question I had is, so you're moving,
address-
you're
yeah,
proposing to move the one tower from the side to the back onto the top. The other small tower from the front to the other side, where that existing tower is right now. That's, I wanted to confirm that, because I live on the other side of that. I don't want to look out and see an additional tower standing there, no matter what height it is, quite frankly. And the other aspect of it is I have concerns. There are a lot of mature trees around. Those trees fall and hit that tower, whether it's grounded or not, could have some serious complications. I mean, if something broke on that tower and it hit his house or one of my neighbor's houses or my house, it's going to go right through our roof. So I'm all for people following their passions, but at the end of the day, this is not what we were looking for when we bought a house in a residential neighborhood. If I wanted to live around cell towers like that, I would have lived downtown.
Thank you. Are there any questions from the board?
No, I don't have any questions.
No. We're-
You're the house at the top of this picture, is that right? Just
Um,
immediately next door? Okay.
You mentioned 36 cell towers?
36 towers where there's amateur radio involved.
Okay, thank you.
Yeah. And that was just based off a Google search. I'm not an expert in the field on any level.
Any other questions from the board?
Thank you.
Is there anyone else who'd like to speak in opposition? Would you like to rebut anything that was said?
As far as it goes with radio interference on cell phones, pagers, low-level electronics that was said, my equipment is well-maintained and within the standards of the FCC for my license parameters, and it will not cause any problems to any device that is properly made. That's the rules the FCC has set forth. As long as I am within my guidelines, it is the other instruments problem that cannot deal with the quote-unquote interference. However, since we have lost analog TV, there is almost no interference at all caused by ham radio operators anymore, and that was on 6 meters back when we had analog TV. As far as to the safety concerns, it will be a well-built structure. I would consider it less of a concern than a monopole falling on a substation, which would be the case up by the Honey Store should we ever have a problem with that. There are no power lines for it to hit, and if there is wind big enough to take down one of the large mature trees or take the roof off a house, it's not going to make any difference. It's just an act of God at that point. Plus, it will be insured.
Any questions?
If you know, I'm just thinking, I don't know how it factors into our decision here, but I'm trying to think it through. I'm trying to consider some of the concerns that were raised. Do you know anything about the structural integrity of these kind of towers? Do they ever fall down? Do they tend to break at a certain level, and could they reach your neighbor's house? if you know, and if you don't know,
You,
that's
sir, the only thing I can tell you about tower construction is that when they are guyed properly, as Dan had mentioned earlier, you've got a 200-footer plus behind the fire station. When they're done properly, they have a wind survivability of about 110 miles per hour. The antennas I have specified have the same wind survivability, and it is built to more than standards of the amateur radio community.
Looking at this site plan here, tower number 1 is the tall one. We've talked about 3 guy wires, right?
Yes, sir.
Can you give us a sense, by reference to this photo, of where those wires will be anchored and how long the guys are?
Well, if you come in front of my front porch, you see where the porch kind of turn, you've got the 90-degree section right there.
Sure.
You come down, you got the 90. The one in front yard would fall right in there. The other 2 would fall back right around where the gravel ends on the back paved area where the gravel stops, right before they hit the grass, and the guy poles will be on my property.
And they'll be roughly in the middle of the property, between the property lines, roughly equidistant from each property line. Is that the plan?
Yes, sir.
Okay. And how high are they on the tower? One was 60?
It is supported at the house at 20, it is guyed at 40, and it is guyed at 60.
I'm trying to, I'm thinking out loud, but I'm thinking, if the tower falls and the guy holds,
Then it doesn't go.
it doesn't go, but even to the extent it went, could it reach your neighbor's house? And again, I don't know that that matters for our zoning thing. I'm just trying to.
I honestly don't know. I've kind of played this with my mind in all the angles possible should some tragic event happen. But I know it won't hit any power lines, I can tell you that.
There's at the very back of your property, I was there this morning, sort of on your west property line, kind of in the northwest corner, there's a very tall, very dead, maybe ash tree.
Yes, sir. It's slated to come down within the next 2 or 3 days. I already have a company contracted to take it down.
Do you know how tall that tree is? I'm trying to visually.
I have no idea, but I bet the top branch is right up there about 100 feet.
And again, you're saying that based on your experience, your equipment will not interfere with cell phones, Wi-Fi, Bluetooth, etc., of any of your neighbors?
Sir, things
I
that,
know that's not our zoning jurisdiction.
things
I'm
that
just trying to
operate
get the facts.
inside the amateur radio band parameters and our transmission quality standards will not affect any properly built electronic device.
Gary, I have a clarification. Do you know if there's permitting required for the construction of the tower?
That would be up to the building department. I don't, Brad, you guys.
Hamilton County is hands-off. I had already asked
Okay.
them about a permit for it. They said we don't do that for amateur radio towers.
Okay.
I'm not surprised.
Is maintaining your equipment to FCC standards part of your licensure requirements?
Absolutely, sir. I'm an amateur extra. That is the highest grant level there is at this time with the FCC. And professionalism for not only myself, my hobby, and others who enjoy it in my area is a foremost concern.
Any more questions from the board? Thank you. Okay. Anyone else wish to speak either for or against? Hearing none. No objection from the board. We will close the public hearing.
So moved.
Second.
Mr. Nye?
Aye.
Mr. Cyan?
Aye.
Mr. Haber?
Aye.
Mr. Halpin?
Aye.
Mr. Shekels?
Aye. Would anyone like to start the discussion?
I will. It's my understanding that amateur radio antennas There's a state law that circumscribes our normal zoning review and forecloses consideration of certain items. We are obligated to permit it, essentially, within certain bounds, but notwithstanding our zoning resolution here in the township, the state says you can't interfere with the ability to establish effective radio communications. So in certain situations, we can say, put it here on the property or not there, or that kind of thing, but we can't say don't build it. And so while we might have some authority to say, move it around, there's nowhere obvious to move it here. Anchoring to the house makes sense. You in theory, I suppose, could put it farther in the backyard, get a little bit farther away from the house, but anchoring to the house makes sense, and other things. So I appreciate the neighbors' concerns, but I don't think we can do anything about those. I think also, based on what I know and the testimony we've heard, the equipment won't interfere. He risks his licensure if he doesn't maintain the equipment. I think we could condition the variance on the maintenance of the license. And so if he loses his license, the tower's got to come down. I don't know why we couldn't do that. I think that's about the extent of our ability to protect the neighbors from, I don't want to call it an eyesore exactly, but I think that's part of the concern. I don't think we can do a lot more.
Gary, I got a question. You concur with Jeff's basic statement. Now, the other question I would have following up on that, can we condition that if he loses his license or moves? Is that within our purview to do?
I wouldn't see why not. I mean, you're granting it under the specific authority that is, given to the board through the state law, and it relates specifically to, the amateur radio operations. So without that state law authority, then you would have a lot more power. So I don't see why you couldn't condition any approval based on, maintaining a valid license.
Could we also condition it to he sells and moves to another house somewhere else, or is that a condition we couldn't install?
If he sells it to another ham radio operator, then the condition would cover that.
Conditions would go away.
Right. Yeah, it would be able to stay there because obviously a variance goes with the property, but because this is tied to the allowance of ham radio operator to operate at a height higher than what the township allows, I think a condition that if the owner of the property or there's no ham radio operator, licensed there, then the tower should come down. Because I assume, again, Mr. Meyer said he's got, the insurance in relation to what he's doing, but if he moves and nobody's got a license there, I assume that they wouldn't maintain insurance to protect the tower. Maybe wrong, but, that's a possibility.
Please come to the podium. Okay.
Should and when I decide to move, the tower will be going with me.
Fair enough.
I hope that settles that. I have no intention of leaving it for the next person. One caveat to that, of course, is if there is an amateur radio operator who wants to buy the house and says, I'll take the tower with it, I will, of course, at that point, not take the tower down. My licensure is good for 10 years. When you're an extra for life. So I have no problem maintaining my license and my licensure as part of this agreement.
Okay. Thank you.
You're welcome.
Further discussion? Anyone on the board like to carry the discussion further? Nope. Steve? Paul? Okay. Is there a motion out there anyone would like to propose?
Are there any staff recommended conditions on this one? No, there's not, right?
No, I don't believe so.
I would support a motion with the caveat that if the licensee loses his license or moves, then the tower must be removed.
Right, with the condition that a licensed operator
Operator who
resides.
would buy, yes, would buy the house. That'd be the other condition. If a licensed operator buys the residence, he could, I'll recognize
I
you,
think,
Mr.
Mr. Chairman, as long as there is an amateur, licensed ham radio operator associated with the property,
That's it.
obviously it doesn't have to be the owner. It doesn't necessarily have to be the tenant, but somebody that may sublease, if you will, the basement of the house, wherever the radio equipment is. As long as there's a licensed ham radio operator associated with the property, I think would be sufficient.
Would it have to be a resident or an owner?
I don't
Just
think
an
it'd be
owner?
either.
Either? Okay. I know you have something to say.
I mean,
Anybody else?
because, I mean, obviously, for example, if, Mr. Murray wanted to, well, let's take it out of his hands, but if the owner of the property wanted to allow, a son who doesn't live there to have a, ham radio operation in the basement, assuming they meet all the FCC regulations, they have a license to operate, then, that would be a ham radio operator having permission from the owner to operate on the property. I think that would be valid too. That's why I say it's somebody who's associated with the property, which would be somebody that's either an owner, an occupant, a licensee, like the son would be a licensee, be able to come in to use the property for the ham radio purposes. So I don't want to narrow it too far down to owner
Right.
or occupant even, but someone associated with the property.
Okay.
And
Well-
Mr. Powell, can I get clarification on if the board were to do a condition that they can't limit who lives on the property or
Correct.
who leases the property? So I just wanted to make that,
Correct.
make sure that was the right.
Just
Right.
that whoever it is has
Right.
to have a license.
Not
As long as
whoever-
there's someone associated with the property that has
Yeah,
a license to
have-
operate
that's
on that,
right,
yes.
yeah.
Whoever is using the amateur radio antenna needs to have a license.
Right.
Okay.
Go ahead, if you wanted to step up and
Yeah,
state something.
I just had a thought. Is there, I think of Anderson Township and I think of, the trees and that's what drew us to this area. So is there another structure that's 10 stories high that's in Anderson Township that's a freaking pole? And I know you say that as far as the visibility of it and what it looks like, you know what? It's an eyesore. So I applaud him for doing what he does, but perhaps it could be a little shorter because that would take care of all the avenues. But 10 stories is a big structure. It's tall. And then it has things coming out of it. And so that's what you're going to see. I mean, and it's not like the pole at Salem and Sutton, because that is not affecting anybody that drives by. I mean, there are commercial buildings across the street. So there has to be a way that it's good for everybody. So I have.
Okay, thank you. We appreciate your concerns, and we'll take them under advisement.
I mean, let's talk about that. I think we heard testimony about why 103 feet. Would 93 feet have worked? I don't know that we specifically asked that question. Is it appropriate for us to get into that?
Well,
Gary, I'll defer to you on that.
I understand the public's concern about this because obviously what they're raising are typical zoning concerns. The board doesn't have the authority to kind of balance those competing interests. The Ohio law is very clear that the legislative authority shall not restrict the height or location of amateur station antenna structures in such ways to prevent effective amateur radio service communications, and they shall reasonably accommodate amateur station communications and shall constitute and shall constitute the minimum practical regulation necessary to accomplish the legislative authority's purpose. So there's very little that the township can do, other than if they find there's a severe safety problem with the tower he's got, things like that, or that he's proposing. He's already testified that he thinks the 103-foot tower is what he needs to effectively communicate, and he's given some reasons why. And, you know, if for example, you would deny it, then it would be up to the board to justify their reasons if it goes to court. And so again, it's a much different situation when you're dealing with a ham radio operator review by the township zoning board than it is typical zoning cases. So you're very much constrained, and you know, the law is very clear. You don't have a lot of leeway, and you know, you can't decide, well, 93-foot tower is going to be okay when he's already testified that he needs a 103-foot tower because of, for example, obstructions in the area, such as the trees. So, and it, you know, because I've done a decent amount of reading in this antenna height and communications effectiveness manual that I found somewhere on the internet for a guide for city planners and amateur radio operators, and the technology is very difficult to understand. Obviously, somebody who's got a license has to spend a lot of time in order to get their license, understanding the technology, and the difference in heights helps determine how far your signal can go, how far it has to go before it bounces, and get all this kind of stuff. And so for us to stand here and say you only need 93-foot tower, I think would be, I would be worried about that.
I wouldn't support our restriction on the height of it.
Right.
Well,
You would?
I would not.
Would not.
let me say two things. I agree with everything Gary said. It says the minimum practicable regulation necessary. So basically, we can regulate for safety, and maybe not even then. Like, we get absolute minimum. But I think maybe we should put the question back to Mr. Murray just one more time. Could you do 93 feet? Could you do 83 feet? I think I know what the answer is going to be, but let's get it in the record so we know. We don't have to guess.
Can you come back to the podium? Okay.
I mean, I appreciate the concern of the neighbors here, but
I appreciate the
General Assembly
concerns
says
of the
we
neighbors
can't consider
also.
that.
The height was a consideration. It was actually a compromise tower at this point. I would like to have gone 80 feet, but I felt because of the neighborhood that would be inappropriate. And that would have been 80 feet of tower with a 15-foot mast with a 24-foot antenna on top. That would be 80 or about 95 feet of antenna structure, or excuse me, and 95 feet of support structure with a 24-foot antenna on it. As far as the antenna itself goes, that it will be on the top, it is a thin white monopole and almost invisible as your photograph showed. That would be the top of it. The actual structure tops out at 75 feet, the 78 feet including the foundation, of course. But the upper tower, the upper portion of it is 24 foot long, and that's what gets you your final height. And that only weighs about 8 pounds. And it's made of fiberglass, and it's extremely flexible. And as far as lowering it, anything that puts me behind trees, bad. Just, I'll sum up UHF, VHF communication very simply. Tree, bad. Open airspace, good.
If you wish to address, well, you're coming to the podium. Okay.
Well, that's actually what I was going to ask. Like, the tree in the back is coming down,
Yes, sir.
but I live around the corner on Eversole, so I drive through there all the time. I mean, when that tree comes down, I guess maybe it's the one just over the window on the right of your house there, I think is the one it is.
Actually, if you look at this wire right here, right in this picture, see that wire? You see that tree that's kind of, no, the other side, sir. This one over here. Follow that wire down. Keep following. That tree right there is the one that's coming down. That's a dead tree.
That's the guy. And is it?
I believe that's the dead tree. The angles were.
This one over here too?
Yes, sir. That's the dead tree. The other one is alive. I apologize.
Well, so is that an oak tree to the left there that's partially?
Yes, sir.
I mean, you can't trim that.
No, sir. You can't
And
trim
even
it.
if you did, there's one on the other side that's just as tall.
Yes, sir.
And there's one on the other side that's just as tall.
Yes, sir.
I really want to address the neighbors' concerns here, but I don't think we can.
Listening to the testimony, I think that his assessment of the elevation, the height he needs, is what we need to go by.
I think that's what the General Assembly said.
I mean, I would be more than happy to compromise and go higher.
Okay. Any further from the board for this?
No, but
gentleman?
I see.
Yeah. We have anyone else who would like to testify? You have already, yeah, you've been here before.
That tree in that first picture to the right, that's sitting behind my house, that tree is slated to come down as well because it's dead. So that tree is not going to be a factor. We had three other trees removed last fall after we bought the house. We were waiting to see what happened with that one, and that has shown itself to not be live. So that tree's coming down.
So on the left-hand picture,
Correct.
the tree in the middle,
So the one you're looking at,
is
the power
gonna come
lines,
down.
right there in the middle is coming down.
and then the one behind, it looks like it's like this, behind the house over on the right, that tree's coming down as well.
That is correct. That tree on the right there that you're looking at is on our property, and we're in the process of having that taken down. It's a dead tree.
Anything else you'd like to add?
No, I just wanted to clarify.
Thank you.
And the other clarification I'd like to make is, if that Mr. Murray never did answer the question, if that tower were to fall or break at some point, it would absolutely hit our home.
Any further testimony for or against? Any further testimony for or against? Okay.
Well, I want to ask one more question, and that is, given the additional testimony, if I'm correct, is that the tree in the picture on the left, the tree in the middle is coming down, that's on your property.
Yes, sir.
And the tree over behind the house to the right, that tree is also coming down, given what the lady just said. Does that change your requirement?
We still have a massive surrounding tree line.
Okay. Just following.
Yeah, and I think my judgment, based on my knowledge of the area and the testimony we've heard today, is that notwithstanding those two trees that are coming down, there are plenty of trees at or about 100 feet around.
Mm-hmm.
And if you got to be above them, you got to be above them. And so then the only question is, can we say, well, push it a little farther back from the road or something? And the problem with that is, then you're losing the ability to anchor it to the house, and you may be making it less safe. I think also, if you have it guide, one in front, one in back, it's probably not going to break, but if it did, those guys will prevent it from falling very far. I can't guarantee they wouldn't fall outside the property line, but I think the General Assembly is telling us that we can't really get into that.
No.
It's just not within our purview, unfortunately. Or fortunately, maybe, I guess. I mean, I really feel for the neighbors here, to the extent that they think it's going to be an eyesore. And that's not necessarily even my judgment that it would be, but I appreciate that concern. But the General Assembly, in its wisdom, says that these 5 unelected folks up here can't consider that.
Any other considerations or comments from the board? I would support this with the option regarding, I don't know how, Gary, I'll leave that wording to you.
Someone associated with the property.
Okay.
What was that, Gary?
Someone associated with the property.
Yeah, maintain an amateur radio license. So moved.
Is that the resolution?
Yeah, I move that we grant the variance subject to the condition that someone associated with the property maintain an amateur radio license.
I'll second the motion.
Mr. Nye?
Aye.
Mr. Sion?
Aye.
Mr. Haber?
Aye.
Mr. Halpin?
Aye.
Mr. Shekels?
Aye. Okay, can we move on to case 8, 2022, 7150 Ragland Road?
Yeah, so case 8 is going to be, as Mr. Chair just said, 7150 Ragland Road, and that is the Hermitage Club lot number 22. Property zoned A residence. The applicant is requesting a variance to allow for a new single-family house with a front yard setback of 39 feet 9 inches where 50 feet is required, per Article 3.3 C2A. The proposed development, again, is a new single-family house. It includes a covered deck, and lot 22 of the Hermitage Club, where a house was previously demolished. The applicant is proposing to use the existing garage foundation from the previous residence for construction of the garage of the new residence. Applicant is proposing a front yard setback of 34 feet 9 inches, I think is what we had on the last slide. The property was developed as a single-family residence within the Hermitage Club. This is a corporation founded in 1920, owning 244 acres of wooded land in Anderson Township. 27 members jointly own the property, and each leases 1 acre as a personal leasehold and residence. In July 2007, a zoning certificate was issued for a 24 by 24 foot garage addition. At the time, this garage was in the side yard area, as the house was closer to the private drive. The residence was recently demolished, and the applicant is proposing to reconstruct a new residence set back further from the private drive. The foundation from the from the previous garage would be used for construction of the new garage. So this is just an overall map of the Hermitage Club property. This is a map that I believe was provided by the Hermitage Club. This is lot number 2022. As you can see, that lot backs up to the lake for the Hermitage Club. The red dot on this property here. This is kind of a zoomed in view of the aerial map. This is the previous residence that was on the property. This right here is the garage addition that I mentioned, which is to be used for construction of the new house. There is a retaining wall on the property, and so these private drives all access obviously more than 3 houses, meaning that the front yard setback is taken from the private drive as opposed to the leasehold line. This is a topography map. As you can see, it slopes down towards the lake. So this is provided by the applicant, and previously the house sat 17 feet from the road. This is the new site plan that the applicant is proposing. Again, now the front yard setback is being proposed as 34 feet 9 inches. We did do a measurement of this portion of the house right here to the asphalt drive, and it is meeting the front yard setback. As I mentioned, a covered porch is included in the rear yard, or a covered deck. And then this is the front and side elevations of the house for the south and the east portion of the house. And then the rear and side elevations as well. And then these are pictures that staff took while we were on site. This is the garage foundation from the previous house that's being used for the new house, and the retaining wall as well. This is a view looking towards the lake, kind of at near where the driveway is. I believe the proposed house was marked on the property, and based on that, we took a picture where I believe the corner that needs the setback of the house and how far that would be from the property line. I think the applicant would be able to confirm that. This is looking back up the private drive, back towards where the front of the house is proposed. And then this is another view, kind of standing near the rear of the lot, looking towards some of the neighboring residences. And then looking back towards where the front of the house would be. And then lastly, this is a view looking towards the lake area, and then I believe several utilities were marked on the lot. So staff findings, staff is of the opinion that the variance would not be substantial. The new residence would be set back approximately 18 feet further from the private drive. Essential character of the neighborhood would not be altered, and adjoining properties would not suffer a substantial detriment. Property backs up to the Hermitage Club Lake and Dock, which is used by all 27 members. The applicant has proposed the location of the new residence to be further from the previous. The applicant has proposed the location of the new residence to be further from the lake with respect to the privacy of the homeowners and lake users. Further, Don Thomas, the president of the Hermitage Club, has written a letter of support for the new residence. The variance would not adversely affect the delivery of governmental services. Applicant has stated that the variance is needed to preserve the space in the rear yard for the new septic system.
Is that, you stumbled on that statement. The applicant has proposed the location to be further from the lake to respect the privacy. Is it further from the lake or further from the drive?
Yes, it's the setback is being requested so that it can be further from the lake and closer towards the private drive to respect the privacy of the lake user.
Moving it up the hill away from the lake.
And encroaching on the setback.
Yeah.
Building a permitted house is too close to the lake, so they want to encroach on the setback.
Okay, so the residence was recently demolished and the applicant is proposing to reconstruct a new residence set back further from the private drive.
Correct.
So I'm trying to get, are we closer to are we farther from the lake and closer to the drive, or are we closer to the lake and farther from the drive?
We're closer to the private drive to be further from the lake.
We're squished. Yeah. We're further from the lake and further from the drive.
Oh, I see it,
As
yes.
compared to the old house.
Gotcha, okay.
Yeah. Only in comparison to the old house.
Right.
Sorry for the confusion there.
No, I appreciate it.
Yeah. The property owner's predicament could be feasibly obviated through some method other than a variance. The applicant could relocate the proposed residence to meet the front yard setback of 50 feet. However, the applicant is planning to reuse the existing garage foundation as an attached garage for the new residence. And staff is of the opinion that the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance based on the following. Residence would be set back further than the previous residence, set back from the private drive than the previous residence. Applicant's intent to be further from the Hermitage Club Lake to respect the privacy of lake users. The letter of support provided by the Hermitage Club president. The intent to preserve space in the rear yard for the septic system, and the intent to reuse the existing garage foundation for an attached garage for the new house. These are our standards to be considered. Be happy to answer any questions.
Any questions?
Nope.
Okay, none. Will the appellant or the appellant's representative please come to the podium? State your name, address, and your affiliation.
My name is Chris Lewis. I live at 7150 Ragland Road, lot number 24. I purchased a foreclosed house 6 years ago and built our current house where we live. I'm a builder by trade, mainly remodeling, but that was my first house and went smoothly. As I've been in the neighborhood a few years, another house which was vacant, this one, a woman inherited it 20-something years ago, never moved into it. She built a garage addition, never even parked a car in there. The house was under scrutiny from neighbors from being in disrepair, and a lot of the neighbors convinced her that she should sell it. They said, hey, here's a good way for us as a neighborhood to kind of control what's being built there. I decided to go ahead and buy it. The neighborhood's all behind it to help improve the neighborhood. And you've seen a copy of what we intend to build there. It's a reasonably sized house, not too crazy, not too high that will ruin the view around the lake and everything. And we're just hoping that we can get past this front setback.
Any questions from the board?
Do you plan to move there, or are you gonna?
No, we'll be selling it. There's already a couple other neighbors who have friends who have interest in buying it, but we're going to stay just up the hill where we are.
Right, thank you. Is there anyone else present who wants to speak in favor of the appeal? Is there anyone present who wants to speak against the appeal? Hearing none, no objection from the board, we will close the public hearing.
So moved.
Second.
Mr. Nye?
Aye.
Mr. Sine?
Aye.
Mr. Haber?
Aye.
Mr. Halpin?
Aye.
Mr. Shekels?
Aye. Well, I'll start. I see no reason not to support the appeal. We have documents from the Heritage Club stating their support for this, and I see no reason not to move forward with it.
I agree. Not substantial, doesn't adversely affect the character of the neighborhood, et cetera, et cetera. I would grant.
No opposition as well.
Agreed.
Same.
Would someone like to make a motion?
Mr. Chairman, I move that we grant the requested variance.
Second.
Mr. Nye?
Aye.
Mr. S-
Oh.
What?
Well, we need to reference the
Just cite
drawings
staff's findings, I guess.
dated. When are these dated?
On the condition that it be done in substantial conformance with the plan submitted in the application.
Yes.
And built within.
And built, and commence building within
1
1
year?
year, completed within 2.
Start with 1, complete with 2.
Yep.
So moved.
Thank you, sir.
Thank you.
Second.
Mr. Nye?
Aye.
Mr. Sine?
Aye.
Mr. Haber?
Aye.
Mr. Halpin?
Aye.
Mr. Shekels?
Aye. Okay. All right. And now, will the staff please read the report for case number 9/2022, 1289 Collinsdale.
All right. Thanks for being patient with us, everyone. This is our last case. This is for case 9/2022 BZA. The applicant is Rich and Ann Thompson on behalf of 1289 Collinsdale LLC, who's the property owner of 1289 Collinsdale Avenue. The zoning is C residence, and the request is a conditional use and variance request to allow a short-term rental with parking located in the front yard setback area. Short-term rentals are a conditional use in a single-family zoning district per Article 5.4 I-15 of the Anderson Township zoning resolution, which is defined as a rental, the rental of a primary residence or portion thereof for a period less than 30 nights, for which guests compensate a hosting platform owner or leasee of the unit. So again, the proposal is for short-term rental in an existing single-family residence. The applicant has not proposed any changes to the exterior of the property. The variance request is to allow vehicular parking in the driveway within the front yard of this, within the front yard area. The property was purchased by the current owner in 2021, and in 2020, the existing deck in the rear yard was installed. In April 2020, the Anderson Township Board of Trustees adopted text amendments to the Anderson Township zoning resolution, which made short-term rentals a conditional use in the single-family residence zoning district. So here's a property map of the property on Collinsdale. This is an aerial map. Here you can see the deck structure in the rear yard. This is also a shared driveway, I believe, on Collinsdale. This is a topography map. As you can see, it drops off kind of towards the rear of the lot. And this is all provided by the applicant. Again, there's no changes to the existing exterior of the house. This was all provided by the applicant. We wanted to make sure we included all the outdoor areas. This was also included by the applicant as far as technology that they would help help the owner of the property. So these are the staff pictures. This is the front of the property, or the front of the house. Again, it's a shared driveway, and this is a view kind of going back towards the rear yard area. This is a picture taken from the rear yard area looking back towards Collinsdale. You can see the deck structure on the left there. And then another picture of that structure. So, with our conditional use findings, to authorize the grant of a special zoning certificate, the Board of Zoning Appeals must make a finding that the proposed conditional use is appropriate in the proposed location. Findings shall be based upon the general considerations set forth in Article 2.12D8. So spirit and intent, the proposed use and development would comply with the spirit and intention of the zoning resolution and with district purposes by meeting the conditional use standards. The proposed short-term rental meets all the conditional use standards with the exception of the aforementioned variance request for parking in the front yard area. No adverse effect. The proposed short-term rental would not have an adverse effect upon adjacent property or the public health, safety, and general welfare. Applicant has indicated that multiple technologies will be used to screen guests before approving a rental and to alert the property owner of excessive noise or the number of guests. Protection of public services. The proposed short-term rental will respect natural, scenic, historic features of significant public interest. Applicant has not changed the exterior of the existing single-family residence. And then I believe this is consistent with our adopted township plans. It's consistent with the township's comprehensive plan, the housing chapter that states Anderson Township is a diverse housing. Anderson Township is home to a diverse housing options with changing demographics and market demands. And then these are the standards that are specific to short-term rentals specifically. So parking shall not be permitted in the area defined as the front yard setback. As I mentioned, the applicant is requesting a variance from this. Vehicular use area shall be located and designed so as to minimize the impact of the neighborhood. We found this to be in compliance. Measures shall be taken to minimize the impact of potential nuisances such as noise, odor, vibration, and dust on adjacent properties. We found this to be compliant as well. The maximum amount of people that would be limited to 8. Applicant has indicated that minute and party squasher technologies will be used to screen visitors, limiting noise and detect excessive visitors on the property. In addition, the applicant will provide an email address with phone numbers to neighbors in case concerns arise. M, no exterior alterations of an existing structure shall be made that depart from the residential character of the building. We found this to be in compliance. All lighting shall be directed away from adjacent properties. This was in compliance. There was no lighting proposed. Applicant shall provide a plan indicating a manner in which the facility will maintain contact with neighborhood residents along with a structured procedure whereby residents' grievances may be filed with the township and resolved by the facility. This was in compliance. The applicant will provide an email address and phone number to neighbors in case of concern arises. Meals shall only be served to guests or residents of the facility and not to the general public. This was in compliance. And then an emergency response plan shall be submitted detailing safety measures and response procedures. This was in compliance. The property is equipped with fire extinguishers, smoke detectors, and a carbon monoxide detector. Guests will be provided with the phone numbers for both emergency and non-emergency police. According to the Anderson Township Fire Department, there are no additional life safety regulations that the applicant's required to meet. And then as far as our variance findings for parking in the front yard area, staff found staff's opinion is that the variance is not substantial. The existing driveway becomes narrower along the side and the rear of the existing residence. In addition, the applicant has stated no more than 3 vehicles will be permitted on the property. Central character of the neighborhood would not be altered, and adjoining properties would not suffer a substantial detriment as a result of the variance. The existing driveway becomes narrower, therefore parking in the side or rear yard would have more of an impact on the neighboring property to the south. Would not affect the delivery of governmental services. Property owner's predicament cannot be feasibly obviated through some method other than a variance. The width of the existing driveway becomes narrower along the side and rear yard. Therefore, the vehicular parking can only take place safely on the driveway in the front yard on the east side of Collinsdale Avenue. Staff's of the opinion that the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance based on the width of the existing driveway and the applicant limiting the number of vehicles permitted to 3. So these are the first set of standards I went through. This is standards specific to short-term rentals, and then our variance standards. Be happy to answer any questions.
Any questions from the board? Is the appellant or the appellant's representative here? Please come to the podium, give your name, address, and present your appeal.
Good evening, gentlemen. Thank you for your time and your service to the township and its residents. My name is Rich Thompson. I live at 6207 Woodlark Drive, Cincinnati, Ohio 45230. I am the managing member of 1289 Collinsdale LLC that purchased this property. My wife and I originally purchased the property with our long-term intent to move there and live there ourselves. We currently are the residence that has been our family home for many years that's not prepared to sell yet. So in the meantime, we have been wanting to try Airbnb because it's been a great opportunity for us to go to other communities and join those cities, learn about different places, and experience a great trip for ourselves. I've been in real estate 22 years as a landlord and property owner. I've been a licensed realtor for 20 years, and this was kind of a natural progression of that for us as we move forward. As the staff had presented, we felt like we have met each one of the standards and questions that the township had. The unique things we were really excited about, I have a mentor that's doing this in Florida that has 40 units now, and some of the technology was something he imparted to us. So the 2 technologies we mentioned, let me back up maybe before I go there. If I were in the neighborhood living next door, the things I think most of us are worried about are parties and trouble. We want to do everything we can to mitigate that. The minute technology allows us to measure and record and document the volume of noise inside the residence. And we get a notification to the technology to ourselves and the management team that says that this has been violated. If it's short term, it's one time, we send the resident a notice that you violated, don't do that again. Becomes extended or happens again, then we ask them to leave the residence. That's part of our lease with them. The party squasher technology actually measures the number of devices connected to the Wi-Fi. So if we allow 8 people in, it's maybe reasonable at best to have 16, maybe 18 devices. If the Wi-Fi gets more than that connected or sees that at present, it'll again trigger us, send us a notice that there's more than that number of devices on the property. We're being told that technology will radiate about 25 feet outside of the residence. We've not verified that. We've not used the technology ourselves, but that's our understanding. So if they're on the deck having a party, we'd also have that notification. As for the parking variance, as the staff mentioned, the driveway is pretty precarious. Not only is it tight and narrow, but as you get to the point where you turn behind the property, it's actually about a 4-foot drop off to the left into the neighbor's driveway. My understanding is that's been a problem for previous owners where they've got their vehicles hung up on that and they've tore the neighbor's wall up. So, and obviously somebody living there doing that would be a problem. Having somebody that doesn't live there show up and do that, that's not something we want to do to the neighbors or to our clients. Also parking in the driveway down between the houses, it's very narrow and difficult even for the neighbors to get their car by. So we want to facilitate that not being a problem for them any more than it needs to be. So being allowed to park in the front, we think we can get 2 cars up there where there's space enough that the cars can get by, and that would be our hope that most of our clients or customers would only bring 2 vehicles. If not, they park the other one on the street. I believe that's all I have at the moment.
Is that house, is it a shared driveway with the house next to it?
It is not a shared driveway, but they are abutting one another.
Yeah, you said 2 on there, but you requested 3. Didn't you request?
Well, my personal ask to them would be is, hey, if you can only put 2, because if we put a 3rd one in the driveway, that starts to pinch on the neighbor a bit.
Yeah.
So as a courtesy, I'd say, unless I'm advised otherwise, would you only put 2 in the driveway so the neighbor can easily get by? Okay. If there's a 3rd vehicle, I guess they could park in the driveway or they'd be on the street.
Well, that's I'm trying to clarify because you have requested space in the front for 3 vehicles.
Yes, sir.
Okay. And I don't see how you get 3 vehicles in the front there to begin with, but.
Right. Well, actually, I believe our intent was that we are limiting our short-term guests to only 3 vehicles when they visit. And I don't know that we've qualified we want 3 parking spots. We asked for the right to park in front of the setback. Because once you get past the setback, then we're impeding on the neighbor's ability to use their driveway.
Okay. Reference to the party squasher technology, would you accept something to the fact that if not that, you will accept it as equal? You will maintain that and something equal to that?
Sure.
Okay.
And that's an expense, obviously, it's not required by the township or anything else, but expense we are willing to incur because we'd want that same respect if we were living next door.
Do you intend to prevent people from pulling all the way down the driveway and potentially getting hung up on that little wall? Like, do you plan to put a bollard in there, or even paint it or anything, or haven't decided yet, or what?
I hadn't considered that yet. So we haven't had anybody there. I will tell you, we did some work on the inside, some drywall work that was repaired, and had my guys over there to do repairs, and it's pretty hard to get it's really uncomfortable to get something back there. You can do it. I've driven my vehicle through there, but it's one of those things you're like, I don't know if I'm going to fall or not. So that might be a good decision for us. There's actually, right there is a 6-foot privacy gate, and most of the time we keep that closed. And that's probably what we would do.
Any further questions from the board?
Oh, no, John, go ahead. You have no question.
I'm just looking at the picture.
I didn't think to look when I was there. If you know, how many of the neighbors have garages, have parking in the rear, or park in their driveways in the front? Because if it's an owner-occupied single-family residence, there isn't this requirement, no parking in the front.
Agreed.
Do you know how many neighbors in the area tend to park in the front already anyway?
I've not counted. I know 2 of the houses across the street, they don't have the ability to park past their setback. I actually have one of the houses down the street, 1399 Collinsdale, under contract for a client, and that also doesn't have the ability to be parked behind the front of the setback of the house. I hadn't looked at that, Mr. Nye.
Jeff, when I was there, I stood in the front and counted 5 cars parked that I could visually see, and then I went up to Gungadin and just counted as I went down the street, and I found 35 cars parked in front of the house.
Okay.
And
that gets what I wanted.
And if I can add, my wife and I took the liberty to go and knock on the door of the 17 neighbors that were going to be affected by this within 200 feet. Already shared our contact information with them, our email address and phone number for the business, and just met with them and say, hey, this is who we are. If you have questions, you have concerns, let us know. As well as we asked them to be our eyes and ears. We don't expect anybody to put up with crap out of people, and they're the best line of defense for that. So we want to make sure they have the ability to contact us and let us know if and when there's a problem, and no day or night call, because we want to address that. Everybody we met was very supportive in our time with them, so I hope that continues to be true.
Thank you.
Yes.
Okay. Gary, I got one side question on this. So if I decide to rent my house to my friend in Indiana who's coming here for the weekend, do I have to go through this whole process?
I would direct that to the staff.
Okay.
Because I don't want to answer it.
I'm just, as a point of law, that's what I'm asking,
It would be hard to figure out that was going on, would be the main thing. I mean, and that would not be a business doing it that way.
Okay.
Yeah.
But obviously, if you're in it for business, that's a different kind of situation.
All right. Just goes. Anyone else like to speak in support? Anyone in support? Anyone against? Please. We'll go this way. First, you go to the podium, give us your name, your address, and state your reasons.
Thank you. My name is Mike Voorhees. I live at 1280 Collinsdale. We have lived there for the last 34 years, so I can tell you a whole lot about the neighborhood if you want. We live directly across the street from this property. I appreciate the safeguards that you're proposing. I would love for you to move in, but frankly, I don't want to live across from a motel. I don't care what you call it, it's a motel. It's long-term leases are fine. Weekends even fine to a friend. But my daughter lives near one of these Airbnbs on Huntcrest, and it's traffic all the time. And if you know Huntcrest, it's, that's not a busy street, really.
Where's
Collinsdale.
Huntcrest? I don't know Huntcrest.
Huntcrest is off of State, and she lives at the corner of Spicewood, and there's an Airbnb right behind her. Now, that's a good question. Do they have to go through this? I bet they haven't. That's another issue. So I think I asked Brad about that, and I think it's a new amendment.
Yeah, the text amendment was recently adopted.
So it's a busy street. It's a cut-through street. A lot of people cut through Collinsdale to avoid that nightmare they call the whatever that thing they put in at 5 Mile and Beachmont. I still can't figure that stuff out. So we do get a lot of traffic, and if there's a motel across the street from us, we're going to be backing out into all these cars. And, I appreciate like I said, I appreciate the safeguards, but they're not going to be there watching. It's worse than a motel because there's no clerk or anybody to complain to. I like your phone numbers. I appreciate that too. But why don't you just move in? So we're very much opposed to it. It would. I disagree with the staff report. It would change the neighborhood a great deal. I go back 34 years there. When we moved in, the Collinsdale was a much wider street. And they changed it, and I can't tell you when, maybe 20, 25 years ago, they put the aprons or whatever you call them, and the street got a lot narrower. It used to be, many years ago, you didn't have to pull over. If you noticed, if you went down Collinsdale, whoever went down, and you said you went down to Gunga Den, somebody did, you have to watch the oncoming traffic, and you have to pull in, and everybody's always dodging. Well, that wasn't that way. This is only going to increase the problem. There'll be more cars, and I know they want to limit the number and everything, but it's going to increase it. It's going to change the neighborhood, and I'd ask you not to grant this.
Any questions from the board?
Same question I put to the appellant. Since you're familiar with the neighborhood, can you tell us, do the folks who live there tend to park in their driveways in the front? That goes to the variance aspect of this, but can you tell us what the conditions are on the street?
We do, and our neighbors next to us, which they just moved in, they're new, and the other neighbors on the other side, they're off the street, but up and down the street, they don't. Now, it used to be before they narrowed the street and did sewers and everything else, we could park in front and have plenty of street where people didn't have to dodge in and out of cars. But it's a different street than it was 34 years ago. Did that answer your question?
I think so.
Okay.
Any further questions? Thank you.
Thank you.
Next gentleman.
Good evening. My name's John Puckett. I live at 1324 Collinsdale. Lived there for over 20 years. And I'm against putting in a so-called motel or an Airbnb or short-term rental. The neighborhood is consistently a single-family neighborhood, and we'd like to keep it that way. Allowing short-term rentals in the neighborhood, I think, would bring the property value down. I can't see there's any benefit to it whatsoever, especially to the neighborhood or the Anderson Township. The only benefit is going to be for the person that owns the property to have an income coming in, because basically it's a business. So I'm totally against any short-term rentals in the neighborhood.
Okay. Thank you. Any questions? None. Thank you. And I believe there's one more person who wants to speak against.
Hey guys. All right, you guys all deserve a beer after this. This is an extremely long event, so good on you guys.
We need your name.
My name is Ryan. Ryan Grace. I live at 1303 Collinsdale, so it's probably just out of sight there. So there's one property next and then the open yard just on the top of the picture where it's cut out is 1301. That's my property as well. So I am opposed to this. We've probably all stayed in a lot of Airbnbs. This is not the neighborhood for an Airbnb. I have an 18-month-old, and there's already tons of traffic on Collinsdale. They've all spoken to it. I mean, people go fast up and down the street. All the neighbors kind of make the neighborly joke that why isn't there a speed tracker sign already? There's already a lot of traffic, and people do park on a mix of driveway and in the street. That's just because of what the mix of houses allows. So it's not really like by choice or by style. It's just there's the first probably 6 or 7 houses on each side, including mine, have driveways, so that's why they park there. But then kind of getting after that, there's just like minimal, kind of like one car little mini lots. There's not really like a place to park for the cars. So then it gets very crowded on one side of the street for parking there to address that. And I also did a little bit of research where like Ohio is the one state where it prohibits registered sex offenders from residing within, I think, a mile of schools. And at the bottom of the hill, there's Forest Hills Elementary. I'm not cool with that. I think that's super uncomfortable for anybody with kids. And yeah, I mean, just to the general theme that we're like a quiet single-family neighborhood. It's not necessary to have an Airbnb here. Like I've stayed in 100 Airbnbs. This is not the neighborhood that you'd go seek out an Airbnb. But yeah, there's no practical there's just no like enrichment to be made to the neighborhood for this. I appreciate Airbnbs. They serve the world, I guess, but this is not the neighborhood for it. I mean, the only like attraction that people from out of town are going to stay from occasional business purposes, sure, but it's going to be Reds games and Riverbend concerts. So that's not, it's not going to be a nice, quiet getaway to the hills of Anderson, right? So, yeah, I mean, I respect it, but I don't get it. So no, I'm opposed.
Any questions from the board? Thank you.
All right.
Is there anyone else who would like to speak against this? Would you like to rebut anything that was said?
First of all, if I may, gentlemen, thank you for coming forth and sharing your concerns. And we want to work with you guys to address those because my own neighborhood, I would want the same thing. A couple of things first. One, we have the privilege and the honor of being the first folks to come through this process here. We're not the first ones to be operating Airbnbs or short-term rentals here in Anderson Township. I hope that speaks to our character and how we do things that we chose. We've been sitting empty, ready to rent for 45 days and been waiting for this process because it's really important to us to honor the system and honor our fellow residents. This isn't a $29 a night motel. Our prices will be in the $200 to possibly $300 a night. So the class of people we'll be getting won't be just yahoos off the street. The benefits to the township were some of the concerns that people had brought up. The benefits are we're going to bringing money into the township to be spent here from outside of our community, as well as many of the people that come to visit are either local family members coming to visit, which we actually had several of the neighbors on the street say, wow, great, we can't wait for our family to come for the holidays and stay across the street, as well as traveling nurses and traveling businesses. Folks are the majority of the people that we have heard and other people in the area they're getting business from. The traffic concerns that everybody has, I understand them and empathize, and 3 more cars are not going to change that impact. It's already pretty bad from what they're describing. It sounds like a different solution might be an option to address that problem, not limiting it us. As I believe Mr. Grace said, he sees the value in Airbnbs and the benefit of them and has enjoyed them himself, and we would like to offer that to others to show them what Anderson Township's like. It's a great community. We have great resources, we have great businesses, and we want to share that with them so that, many people are traveling. Let me back up. The interesting thing about our real estate economy, being a realtor, we are now a national real estate market. We're no longer a regional market. What that means is people that work for companies in other areas can move to smaller cities at better housing costs. I've sold several houses to people moving from the West Coast. They buy a one-bedroom apartment for $850,000 there, or they can come here and buy a McMansion. And we love the opportunity, the idea of being able to be the people to bring them as guests here, to introduce them to Anderson Township, to bring quality people that are making good money into our community. The other thing I hadn't mentioned, we do have a video recording Ring doorbell on the front door of the property that will record whoever comes in and out. We wouldn't and aren't allowed to do them inside, but we will on the outside. We're also using a third-party management company to vet and schedule all of the bookings and things, and they use their exterior system to manage who's coming and who's not. So we're hiring them to take care of that for us. Thank you.
Okay, thank you. Anyone else want to speak either for or against?
I appreciate what he's trying to do, but I believe that the Forest Hill Schools is one of the better schools in the state of Ohio. And there's a lot of businesses or a lot of people wanting to move into Forest Hills that are looking for single family homes. And I think a single family home is a lot more value than a short-term rental. And I think you need to consider that, because I really believe that Anderson Township is single family, and we need to keep it that way and not get into the rentals into the neighborhood. Thank you.
Okay, thank you. Any further comment? Any questions from the board for anyone who commented? Okay, none appearing, no objection from the board. We'll close this hearing.
So moved.
Second.
Mr. Nye?
Aye.
Mr. Sion?
Aye.
Mr. Haber?
Aye.
Mr. Halpin?
Aye.
Mr. Shekels?
Aye. All right, who wants to start this off?
I think I will. One of the things that we do as a board is sort of execute policy that is adopted by the trustees, right? We don't make the policies, and the trustees have told us that one of the policies is to encourage short-term rentals because Anderson Township is home to diverse housing options to meet changing demographics and market demands. The official policy of the township is to encourage the development and redevelopment of a variety of housing styles and densities in appropriate areas of the township. So while I appreciate the keep it single family ideal, it is expressly not the policy of the township to do that. So I appreciate, I think it was Mr. Puckett's concern to that effect, but the trustees have told us, no, don't do that. The things that we're supposed to consider is protection of public services, the plans I just considered, and whether a proposed short-term rental would have an adverse effect upon adjacent property or public health, safety, or general welfare. I think the answer to that is no. I haven't heard anything about a short-term rental that adversely affects public health, public safety, particularly when it's limited to 3 vehicles, 8 people. I think it was 8 people. I don't see that's a health and safety issue. I don't know whether any other Collinsdale houses are non-owner occupied, but I bet they are. And whether that's short-term or long-term, it's not obvious to me that that has an adverse effect. So I think this is specifically the sort of thing that the Board of Trustees has told us to encourage in the township. And so I'm in favor of granting the conditional use permit because of that.